thought they'd come hang out with us today.
I'd like to call this regularly scheduled July Commission meeting of the Tennessee Real Estate Commission into session. And this time I'd like to call on Miss Eve Maxwell, our Executive Director, to call the roll.
Okay. Flitcroft, absent. Franks, absent. Alexander,
Present.
McMullen,
Here.
Bloom,
Here.
Collins,
Here.
Grease,
Here.
DeChara,
Here.
Stevenson.
Here. At this time I'd like to call on Gary Bloom, Commissioner Gary Bloom, to lead us in our invocation this morning.
Let's pray together. Father, we want to thank you for the safety that you provided for those who had to travel here today, and we're thankful for our health. I want to thank you for the freedom that we're able to enjoy in this country, and for, in that environment, the opportunities that we have economically. And pray that you be with us today as we deliberate over these issues, and pray that we'll cover our discussion with wisdom, and pray that we'll make the decisions that will be helpful to the advancement of the real estate cause in this great state. And this we pray in the name.
Amen. Next is to adopt our agenda. Are there any additions? I know last month, one thing that we did, we had a Pledge of Allegiance. Where do you want to do that?
Right now?
Okay, we'll do it right now then. Let's all stand. We're going to have the Pledge of Allegiance to our flag, especially this time of year since the 4th is Friday.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Getting back to adopting of our agenda, does anybody have anything that they would like to add to our agenda before we formally adopt what has been presented?
Motion to approve the agenda.
Second the motion.
We have a motion by Commissioner Collins to approve our agenda and seconded by Commissioner McMullen. All in favor say aye. Aye. Opposed, no. Agenda is approved.
Motion to approve minutes.
Second.
Have a motion by Commissioner Collins to approve our minutes from our June 2014 meeting, and it's been seconded by Commissioner Grease. All in favor say aye. Aye. Opposed, no. Motion carries. Next on our agenda is the election of chairman and vice chairman. And normally, our executive director handles the election, handles this part of our agenda, but since there is not any hope of, or not any prospect of the chairman's name being placed in nomination for anything.
For a multitude of reasons.
For a multitude of reasons.
I second that motion.
I'm just going to handle the election of officers since my name won't be placed in nomination for anything. So at this time, the floor is open for nominations for chairman.
Mr. Chairman,
Commissioner McMullen.
I nominate John Grease.
I'll second that.
Motion has been made that we elect John Grease as our chairman for the 2014-2015 fiscal year. And it's been seconded by Commissioner DeShara. Any other nominations want to be placed on the floor?
Nomination cease and he be elected by acclamation.
Second the motion.
Commissioner Alexander makes a motion. We cease nominations and we elect Commissioner Grease by acclamation, and it's seconded by Commissioner McMullen. All in favor say aye. Aye. Opposed, no. Congratulations, Mr. Chairman. And now for a vice chairman. Floor is now open for nominations for vice chair.
I'll nominate Commissioner DeShara.
Commissioner DeShara's name has been placed in nomination.
Second.
Seconded nomination for Ms. DeShara. Any other nominations? Anybody want to make anybody else a nomination for vice chair? If not, then the floor would entertain a motion that we close our nominating process and elect Ms. DeShara by acclamation.
So move.
Commissioner McMullen has made the motion that we close the nominations for vice chairman, and seconded by Commissioner Alexander. We elect Commissioner DeShara vice chairman for the 2014-2015 year. And all in favor say aye.
Aye.
Opposed, no. Congratulations to you two. And I will say one thing, Commissioner Grease, this commission is in good hands.
Thanks to the members of the commission for your confidence, and I look forward to representing and working with all of you through this next year. To the audience, I'd like to make sure it's clear in your mind that Commissioner Stevenson has not been found guilty of any particular crime. He is term limited, and he's at this moment serving on a month-to-month basis at the pleasure of the governor. So we hope he stays for a long time, but he's right in the fact that at some point he's out of here, and it'll be a shame because he's been a great fellow to follow and watch operate, for lack of a better term.
And I also would like to say, I said to Commissioner Grease as the chairman, but also to you, Janet DeShara, the commission is going to be in good hands with you serving as our vice chair too.
Thank you.
And congratulations to both of you. Yeah, as he was saying, you can only serve by statute 2 consecutive 5-year terms. We're appointed by the governor. I was appointed in 2004 to a 5-year term by Commissioner Bredesen, reappointed in 2009 to another 5-year term. And my term expired, my second 5-year term expired midnight 2 days ago. But the statute says you continue to serve until your appointment is named. So I'm kind of technically still on the commission. But anyway.
Does your vote count?
Yes, it does.
You're on the commission.
I'm still on the commission, yes. But anyway, Mr. Chairman,
Thank you.
the meeting's yours.
Thank you, Mr. Chairman. Next order of business is an informal applicant appearance. Francis Stephen Beal and William Fred Scott. Are you here in the audience? Gentlemen, if you'll come up and take these first 2 seats on this side of the dais. And before you sit down, come right up here, please. Our law director will swear you in. So if you'll just raise your right hand, Ms. Kropp.
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
So you want to?
Talking about that, I'm talking about this.
Okay, Mr. Beal, which is Mr. Beal?
Well, come on.
Bile, I'm sorry. Bile and Mr. Scott. Okay. Ms. Maxwell.
iPad to work. Are you did you swear me in? Okay, sorry. I don't know where I was during that. The applicant for affiliate broker license, Francis Stephen Beal, is here with his principal broker, William Fred Scott. Mr. Scott is the principal broker of McWhorter Realty, LLC, DBA Century 21 Premier, which is located in Brentwood, Tennessee. Mr. Scott, the principal broker, was first licensed as an affiliate broker on 2/23/2011 and was first licensed as a broker and a PB on 6/6 of 2014. The TREC records reflect that the firm currently has 6 affiliate brokers, 1 broker, and 1 principal broker. Mr. Scott has had no complaints filed against him by TREC. The applicant, Francis Stephen Beal, has applied for an affiliate broker license, has passed the exams, and has revealed the following convictions, which involve a theft of money, involving money, services, or property, or a felony. On 10/24/1993, Mr. Beal was convicted in Haywood County General Sessions Court of possession of a controlled substance, marijuana. Mr. Beal paid a fine, and the other charges involved with that were dismissed. On 8/25/1995, Mr. Beal was convicted in the City Court of Jackson, Madison County, Tennessee, of the following: criminal impersonation, a misdemeanor. Mr. Beal was given a suspended sentence of 11 months and 29 days and placed on probation for that time period. On 8/25/1995, Mr. Bile was also convicted of several traffic-related offenses and a noise violation. He paid fines for those offenses and for one received a 6-month suspended sentence, which was reduced to 3 days. On 10/14/1996, Mr. Bile was convicted in the Criminal Circuit Court of Haywood County of 2 counts of possession of a Schedule VI controlled substance, which was marijuana with an intent to sell, and those were both felonies. On each of those counts, Mr. Bile received a 2-year sentence and was ordered to serve 60 days in jail and placed on probation for the balance of his sentences, which ran concurrently. He completed all his probation and paid all the fines and court costs. On 1/4/2007, Mr. Bile was convicted of domestic violence, which was a misdemeanor. He was placed on probation for 11 months and 29 days, and it was unsupervised probation for the final 9 months. He successfully completed that probation on 1/3/2008. Between 1993 and 2006, Mr. Bile had a number of traffic offenses, which resulted in fines, all of which have been paid. Mr. Bile included a long summary of the accounts that were against him, which I sent to each of the commissioners, and I'm going to let him actually go into that in a little more detail. But he really relates that all of the charges were a result of alcohol or drugs, problems that he had in the past that he's now overcome, and that except for the felonies, all the 2 felonies that I mentioned, all the others were misdemeanors. And he's paid, as I say, all his fines. He's been off probation for a number of years. And he says he has most recently been affiliated with Med Solutions, I believe. And I'll let him describe in more detail his occurrences.
Mr. Bile, if you will turn that microphone to you, speak clearly and directly into it. Let me tell our attendees, first of all, there's a box when you try to get a real estate license that says, have you ever been convicted of felonies? And this gentleman has indicated that he has at some point in his past, and today he's asking this commission to waive or at least acknowledge that he had those felonies, those convictions, and would like to proceed with a future in real estate. And that's the purpose of Mr. Bile and his broker being here today. Steve, Francis, you go by Francis?
Fran, sir.
Fran?
Yes.
Okay. Would you, first of all, did Ms. Maxwell have those details correct?
Yes, sir.
All right, now you can add your own words to any extent you'd like.
I would.
Please keep.
Oh,
we got to record this.
I'm sorry. I am and did all those things except I feel that the domestic violence was also there was no violence with that. I also included a letter from my ex-wife, notarized sign that I raised my temper with the police when they showed up. We did get into an argument that day, and the police were called from the neighbors. There was no violence. It's because I locked her out of the house, and my temper was already raised, and the police officer gave me a warning, which I didn't heed. So I was charged. As far as the drinking and the drugs, I do regret some of those things. I didn't feel like I ever had anything to lose until the last DUI. The last DUI, I was married to, I had a great job. I had, we were on the Dave Ramsey track. We were just about debt free. And that day, this is in 2006, I was on my way back to my friend's house. We were working on his car that day, and we had to go back to the parts store. Every time I do something, it takes quite a few trips. And when I didn't use my blinker, and when I saw the cop pull me over, I just drove. I didn't pull over right away. And I went through all the scenarios. I thought about everything that I built up and the life that I had and all the scenarios, that the money that it was going to cost, the strain, my job, it was going to cost my job because I was field service at the time, and a DUI would results in loss of license, and the strain, when I finally pulled over and, succumbed, everything that I was afraid of came true. It did cause the strain in my marriage. It did cause the fights. It did cause the loss of job. And everything that worked over the past 10 years, I lost. And that was the first time I ever felt I lost anything or had something to lose. The ones from when I was younger, I can't speak to. I was dumb. I enjoyed partying. I didn't feel like there was a tomorrow. But when I did build it to where I looked forward to tomorrows and lost it, that I guess flipped the switch and the light bulb went off. And since then I've worked real hard to fly the straight and narrow. It's not even work anymore because it's just, that's life. I mean, I don't want to risk. I've got a new, my wife now, my biggest fan, biggest support, and I don't want to risk what we have.
Commissioners, questions for Mr. Bile? So what was that last date until now? How long's that been?
2006, so close to 8 years.
Questions? Mr. Scott, then we're to you. You'll help us with that microphone as well.
Yes, sir.
Will you tell us why you're interested in having this applicant with your firm and what you know about him?
Well, I met him a couple of months ago. We've interviewed several times. Also, I'm a new broker, as you know, a principal broker. The broker that was downgraded, principal broker to broker, Carla Searcy, has interviewed him. They've had very frank conversations with me included as well. He's had very frank conversations with him included. Also, the general manager, Pat Carroll, who is the principal broker at Century 21 Premier Goodlettsville, has met with Mr. Bile as well. Feel that there was an equal amount of accountability, regret, in talking with him. I think Century 21 Premier has a good reputation. Lord knows I'm not going to mess up. And I've being a small boutique, in meeting with him, I feel that we can train and work and educate him on the proper ways of real estate. We believe in chances at Century 21 Premier, and look forward to working with him.
Commissioners?
What kind of training program do you have at Century 21?
We do everything from ethics to core to just the nitpicky of real tracks to HUDs. It's about a 1 month. What's also always ongoing. We have monthly trainings as well as I'm meeting with them. It'll be a minimum of 12 different classes that we teach. Everything from HUD to working with buyers, working with sellers, proper contracts, etiquette, just the whole realm of things. I've got a whole book that I had to learn to be principal broker of the training that we're doing. And then also Carla Searcy, the broker, she'll be involved in the training as well as Pat Carroll, the general manager at the Goodlettsville office.
Is someone assigned to him to go out with him on his first listings?
I will be, yes, ma'am.
Okay.
And like I said, we're a small boutique at this point with just six agents, 7, counting the one that waiting on his license to come through. So be very hands-on, yes, ma'am.
Other questions?
Mr. Chair, I'd like to make a motion. We approve Mr. Bile for his license.
Is there a second? Seconded by Commissioner Stevenson. Now discussion on the motion. How long have you been a principal broker?
About a week, sir. This is not. It's good to meet you.
How long have you had a license?
3.5 years, sir.
So, now the applicant, what have you been doing since you got on the straight and narrow? You got a full-time paying job?
No, sir. I worked for Med Solutions in the IT department. Kind got laid off about a year or two ago. My lovely wife has an awesome job, and I have been rebuilding the house that we live in, completely remodeling, and that's when I decided to look into the real estate profession and try to expand my horizons that way.
You're a native of Haywood County?
No, sir. I'm actually born and raised in Southern California. We moved when I was approximately 14 to Haywood County.
Other questions, comments? Mr. Scott, this commission has a particular affinity to hold the principal broker responsible. Did you get that in your training?
Yes, sir. Yes, sir.
And so if Mr. Bile has to come back in front of us, and as Commissioner Flitcroft likes to say, who's not here today, you'll be alongside him. You're prepared for that?
We've had conversations in depth about that, yes, sir.
All right, good. Just want to make sure,
Yes,
in a new PB, that you understand that. All right, if there are no other questions or comments, let's vote. All those in favor of Commissioner DeCharo's motion to allow this gentleman to proceed, please say aye.
Aye.
Those opposed, no.
No.
Let's take a roll call, Ms. Maxwell.
This is on Commissioner DeChar's motion to approve Mr. Bile to move on into the licensure process for an affiliate broker license. Flitcroft, absent. Franks, absent. Alexander?
No.
McMullen?
No.
Bloom?
Yes.
Collins?
No.
Grease?
Yes.
DeChara?
Yes.
Stevenson?
Yes.
The motion carries 4 votes yes to 3 votes no.
All right, Mr. Bile, congratulations.
Thank you all.
Go forth and make your broker proud. Don't bring him back here, because he'll come with you if you happen to show up.
No, sir. No, sir. Thank you very much.
Good luck. To the audience, we have one more of these this afternoon, and just from a scheduling point of view, for those of you who are trying to figure out how this is going to work today, we'll take a lunch break at about 11:30 Central Standard Time and be back here at 1 o'clock. And originally scheduled for a 2-day session, this will be only a 1-day session, but we can't tell you with any certainty when it will end today. So if you're catching a plane or have some appointment, if I was budgeting my time, I would plan to be here at least until 5 o'clock. Maybe a lot less than that, but don't get antsy at about 4 o'clock thinking you're getting out, because we got to keep you in here since it's only a 1-day session. On the agenda, we're to the Executive's Director's Report. Ms. Maxwell is the Executive Director of the Tennessee Real Estate Commission. She'll participate quite a bit today in the session, along with Julie Kropp, who's legal counsel for the Tennessee Real Estate Commission. Those are the two folks whose backs are to you at this point. Ms. Maxwell.
Yes. The first item on the director's report is the complaint report, which is a little smaller than it usually is, I'm sad to say, but it does contain the monies that we've collected this month. When it, you'll see on the iPads that in consent orders, we received $4,500. In reinstatement fees, we received $25,280, and agreed citations, $1,200, and one more individual paid the E&O penalty fee, and that was $1,200. So the total amount of monies that were collected for the month of June 1st to June 30, 2014 is $34,560. And then the other item which you have is the disciplinary action report, the part that deals with the individuals who paid consent orders during this past month.
Where is that? Is that a different?
That,
It has its own book.
probably has
It's
its own
toward the bottom. It's about, on my iPad, it's about the 5th one from the bottom.
I see,
titled.
number 17.
Oh, yeah, it's
yeah, they
number
all have
17.
numbers, I
I'm
think,
sorry.
yeah. That's all the complaint information I have this month. I've got to
Like
get.
concise reports. Thank you. Do you recall how the total number of dollars we collected in fiscal year 2014?
No, I really was going to get that, but I didn't get that table yet. I was going to try to do that table, but I'll do that table next month and do it for the whole our fiscal year, which did end June the 30th. And I apologize for not having
this-
that.
Don't apologize.
I'm going to have to make up the tables. I don't have access to those right now.
Safe to say it was safe to say it was several $100,000.
Yes, it was. I mean, it was over 200 last month, and so it was, I mean, it's over that. And I can get that number, I mean, I can get it when I go upstairs from last month's information. I don't know where it is, but I can get it. The next order of business is the statistics. And the first page of the statistics shows the number of licensees as of 6/30/2014. Our number of active individuals increased by 209 to 24,559. Our inactive individuals decreased by 1, so we have 1,127. We have 7,730 retired licensees. We have 306 in broker release, for a grand total of 33,722 licensees, individual licensees. That's an increase of 149 over last month. That does not include the individuals who are currently suspended, primarily for E&O. The firms, we have 3,885, which is an increase of 6 over last month. We have an additional 6 in retirement, bringing that number to 215, for a grand total of firms of 4,100, which is an increase of 12 firms over last month. Our grand total of firms and individuals is 37,822, which is 161 more than last month. And if you go to the additional statistics, which just follow on your pages there, the first page shows the difference in the number of licensees that we have now compared to 2013, 2012, 2011, 9, and 8. You can see from 2008, we had a grand total of 46,973 licensees, and our grand total today is 34,203, and that's just individual licensees who are affiliate brokers, or timeshare salespersons. So the number is very much smaller than it was in 2008, but it is more than what we had in 2013. So we are seeing an increase. We have 301 more licensees than we had in 2013. So we are seeing an increase, and it appears to be more of a slow and steady increase rather than large jumps that might have happened in the past. If you go to page 5 of the additional statistics, that shows the applications approved and the exams taken. And if you'll note, under the exams taken in June, there were 552 exams taken in June of 2014 compared to 418 that were taken in June of 2013. So the number of individuals that are taking exams, primarily affiliate exams, has increased quite a bit over the preceding year. Our applications that are approved for June of 2014, there were 368, and for June of 2013, there were 268. So that number is up as well.
Now, just one thought. Those of you that haven't been on the commission that long, I remember a comment I made about 5 years ago. We were talking about so many people getting out of this industry. And our low water mark, I said, rats don't swim toward sinking ships. But I think this ship is, people are beginning to realize this ship's not going to sink, and there's more people wanting to get into this industry now, which is a positive sign for all of us.
We do have a lot of people whose licenses have been in retirement for a while, wanting to come back out of retirement, and then some who thought they were in retirement and they're not, but they still want to come back. So there has been, that interest of individuals who, I guess, got out of the industry for a period of time who now do want to get back in. One of the other additional statistics, which is on page 10, shows it shows the percentage of non-renewals, and it's based on the letters that go out and the individuals that renew after the 61st day, which is after that sort of grace period. And the non-renewal license percentage this month was 24%, which is the highest it's been in the last 12 months. So that the average for the 12 months is 14.2%, but the 24% non-renewal, as I say, is the highest that it's been in the past 12 months. It's primarily, it looks like, the retired licenses that are just going into expiration, and it may just be that there was a cycle of individuals who are going to roll off anyway and let their licenses expire. There are a number of 4-number licenses, which are the very, very early licenses. But that was quite a leap, to have that be 24% this month.
Could I ask about that? Not that particular number,
Right.
but if somebody fails to renew their license, do they have a period of time, they do have a period of time with penalties to renew it?
They do. They have an initial 60-day, after your license truly expires on the expiration date, but you have 60 days following the expiration date, during which you are in a renewal period, as it were, and you have to pay a penalty of $50 for every 30 days or portion thereof for each of those 30-day periods within the 60-day period. But that's all you have to do, other than meet the other requirements for renewal, which includes education if you need it and paying your renewal fee. On the 61st day, you then fall under the reinstatement policy. And if you fall under the reinstatement policy, one of the things you have to do is come to this meeting, and you have to sign a consent order, and you also have to pay a penalty. That penalty is $50, 30 days or any portion thereof for the days 61 through 120 days after your expiration date. On the 121st day after your expiration date, that penalty fee jumps to $150 per 30 days or any portion thereof, up to the end of the 12th month following your expiration, at which point in time you are no longer able to reinstate, but instead you must retest and reapply, which you can do at any time if that's your choice, because it's a cheaper choice. The maximum amount that you could owe if you went the entire 12 months and wanted to reinstate would be $1,400 in the penalty, and then you would have another $80 to renew, and you'd have to have education, and you have to, as I say, meet all the other requirements for renewal.
Plus attend this meeting?
Plus attend this meeting, correct.
So at any time, you can opt out and take the cheaper route?
You can always retest and reapply. A lot of people just don't like to test, just anything other than test. And if you don't want to come to the meeting currently, you can pay $750 to not come to the meeting in lieu thereof. So that would be in addition to the other monies that you might owe.
Eve, this 24% that did not renew, do you think they were people that didn't want to have a part-time license, or are just ready to retire, or what?
Looks like a lot of them were in retirement. A lot of them were in retirement or an inactive status.
But they didn't retire their license, they just didn't renew anything.
Correct, but some of them were in retirement,
Oh,
and so
okay.
they could have renewed, and they just chose not to. And then some of them were inactive, so that they wanted to go into retirement, but they didn't have their education, so they couldn't have renewed without getting their education. And so those people, I think, some of them just look at the cost and decide they don't want to do it.
If they wanted to come back, what would they have to do?
Those individuals, well, if you if you don't have any education, if you don't have your education and you're in an inactive status, that's not a renewable status because you haven't met the criteria, the condition precedents to renew. So say you wanted to reinstate and your license had been in an inactive status when it expired, before we could even tell you what your penalties would be, you would have to complete your required education. And then, we could tell you what additionally you would owe, because no matter what you do as far as reinstatement, you have to meet the other criteria for reinstatement, to get renewed. Otherwise, you can always retest and reapply.
You'd be starting from zero then.
Correct, and you have to meet all, current educational requirements. So if you'd been, say you got your license really a long time ago and you let it expire, and you didn't take the course for new affiliates because it wasn't required, and you still wanted to be an affiliate, you would then have to also take that course for new affiliates prior to getting, retesting and reapplying. That would be part of what you would have to take, because that's now required where it might not have been required when you got licensed. So it's, and most people, there are a lot of people that just say don't like tests. They seem to not like tests, and they don't want to retest and reapply. Are there any other questions about that? The next thing on the agenda is just a real quick E&O update. As you recall, the E&O statute, which became effective on 7/1 of 2013, required us to put individuals who did not show proof of E&O into a suspended status. So on 7/1 of 2013, we put about 586 people into suspended status. Those were individuals who had not shown proof of E&O. If, in fact, during that first 30-day period, they provided us with proof of E&O, then we would take them out of suspension. There was no penalty. All they had to do was show us proof of their E&O. A number of people did do that. A number of people did not do that. After that first 30 days, there was a penalty fee that kicked in pursuant to the statute of $500 for the first 6 months. And then after the first 6 months, it was $100 per 30 days, and that would be the maximum amount you would owe. It would be $1,200 if you went the entire year. After 1 year of being in a suspended status, the statute requires TREC to revoke those licenses of the licensees who have been in a suspended status for 1 year. So on 7/1 of this year, yesterday, there were still 490 individuals that had been in a suspended status for 1 year. So those 491 individuals are in the process of having their licenses revoked. And even though their licenses are revoked, they still owe that whatever penalty fee attached to them, which is $1,200, they're going to owe that in addition to anything else they would have to do in order to get their license back. And we have actually had one person who called yesterday who wanted to know what the procedure was to get the license back. So, we talked about that last month. Anyway, so that if you look at I have the breakdown of the individuals that we suspended, and then on one column, and then on the far column where it says active, those are individuals who were originally suspended but then showed proof of E&O within that first 30 days, so then they were taken off of suspension. So I just kind of showed you that so you could see how many had complied. Now, we've put more people in suspension in the course of the year, but their year isn't up yet. I mean, we have some people whose year expires 7/15 and then 8, through August, like all through the year we've suspended people. So, the revocations will take place over the next several months. But there were 236 affiliate brokers who will be suspended, 18 brokers, all of whom are, the brokers and the 18 brokers who are revoked, 25 principal brokers revoked, 211 timeshare individuals who will be revoked. So that's a total of 490 that will be revoked before the end of the week. And letters will go out to the individuals and the individual's last known principal broker, some of whom are pretty far removed from their principal brokers. But the letters will go out to those people. And I guess we'll see what happens after that. And so hopefully everyone will buy their insurance at the end of the year.
Those additional statistics you showed us earlier regarding the number of licensees, did it take into account this 490?
No, it didn't. So there are actually more individuals suspended than the 490. This 490 represents those individuals whose licenses are going to be revoked. So I just focused on the people whose licenses will be revoked. There are more than that who are actually in suspension overall. So but that was not included in that number that I read at the first. There are 481 individuals who are in a suspended status just overall in the system.
We shouldn't be surprised if next month the number of licensee drops significantly.
Well, these people will be revoked, and so they'll drop off the numbers that you all see. And then, as I say, actually between now and the next month's meeting, there are probably 30 more people. I'm just guessing. I'm just kind of glancing at the list beyond this 7.5, which is as far as I went looking at the list of people that we had to do immediately. Those, there'll be new people, probably about 30 new people that'll be on that. So we do have some, Mississippi comes due 7/1, so those licenses, we hope those people will show us proof of insurance, and Wyndham's 7/1 as well, one of the largest timeshare that, in our state. And they've already sent in proof for they have a blanket policy, and they've sent proof of insurance for all their licensees into us already. They did that earlier this week. So we're hoping that and we got back today, Julie and I did the amendment, the signed and executed amendment to our E&O contract for, that'll be covering next year, where the commission voted to extend the contract for an additional 2-year period. So as of the signing of that amendment by all parties, Rice is the carrier for the time frame 1/1 of 2015 to 12/31 of 2016.
They keep the rates the same.
Yes, they have to keep the rates the same, which were, I think, $249 for the base policy, and whatever additions, anyone endorsements someone got cost extra. But that will be the base price of the policy, and hopefully that'll allow Rice to get their start getting renewal notices out, and everyone will get their money in a timely fashion, and we won't suspend a lot of people at the end of the year. That's what we're hoping. Are there any questions about the E&O? If not, the next thing on the agenda is an advertising discussion, and I handed out sort of a summary of some information that Commissioner Bloom had sent. And Commissioner Bloom had some suggestions to perhaps change the current proposed rules to reflect just a couple of things that might make them more clear, I think, and easier for individuals to comply with the rules and know what they needed to comply with. And I think that there's also a copy of on the iPads, there's a copy of the proposed rules as they are. And
Yes, it's number 16, draft 5 of notice of rulemaking hearing red line is the.
So that'll be the rules that are currently as they're written, and then the handout that you have is what Commissioner Bloom has suggested, so you can look at the rule that we have it as is, and then look at the suggestions, and I'll let Commissioner Bloom discuss in a little more detail about his proposals and suggestions.
Commissioner?
Yes, well, I'm in complete agreement with the notice of rulemaking hearing as it pertains to advertising, but I really am concerned that we have included in that promotional materials like hats and caps and pins. I don't believe that's deceptive advertising at all if it just said the name of a person. I have friends and acquaintances that advertise Susan B. Koneman. They advertise St. Jude. I have an agent that I know that sponsors a whole race for advocacy against wife abuse, and it's in her name, and that's a great social service, I think. And I don't believe that there's any deception or any concern that the general public is confused about what she's doing. And I just think it's a can of worms for us to try and overreaching, actually, for us to try and become involved in our agents' promotional efforts. I understand about general advertising. Media has to be in compliance with our rules and regulations as we are proposing that. That makes a lot of sense. But the promotional efforts is a concern for me. The other thing is like DocuSign. I don't know how. I don't know how you do that. I don't know how you do what our rules and regulations are proposed on the electronic media, and then like I don't really do this, but Twitter? How do you distinguish whether I send out a Twitter or whatever you call that? Tweet. How do you distinguish if what I'm doing is advertising? And for most of us, everything we try and do, we try and get people to understand we're real estate agents and we're advertising almost every aspect of our life. So I don't know how you could do a tweet and put my company name and my name and us as commissioners be responsible for checking that out. I don't think that's our responsibility.
Okay, Commissioner, sounds like you have 3 topics. Let's see if we can get comments on each topic individually. Promotional materials. Commissioner Bloom is making the case that if Wendell Alexander Realty makes a baseball cap and that's what he wears around town, it would be just as well if he just said Wendell Alexander Realtor and wore it around town. Is that the distinction you're trying to make on this?
Yes. Yes.
It's not having the firm name, but letting those who see that promotional material know that the person's in the business, not particularly trying to sell or list
I don't think
anything.
it'd be a violation for in that instance for someone to create a cap, and in that cap you have to have Wendell Alexander Realty, and my phone number. I just think that's overreaching.
I would agree with that. I mean, if you're giving out ball caps or you're giving out T-shirts, I don't think that's necessary to have the company phone number on there.
I think it'd be the same thing for fountain pens.
Speak up.
It'd be the same thing. You're off.
Yeah, don't tell him what to do.
Don't talk to me. I've had all I'm on for the last 2 years.
Yes, sir.
I think it'd be the same thing with pens and things of that nature. Now, most people will put the telephone number on there. But the caps, I don't see that that's necessary. Everybody in the country gives you a cap.
So we can focus on this. If I can refer you all to your tablet, page 7, under the rules that are proposed, you're in the right place. Just go to page 7.
Mine says 1 through 6.
You're not in the rules.
You're not in the right place.
It's on the wrong page.
17th
Go ahead.
thing, just, oh, no, I'm sorry, not sorry. It's 16th, draft 5, notice of rulemaking hearing red line, page 7.
Yeah.
What's in front of us later today to consider is about 60% down the page, Rule 1260-02-12, subsection or section 1, which now reads, all advertising, regardless of its nature and the medium in which it appears, which promotes either a licensee or the sale of real property. And Commissioner Bloom is suggesting that's overly broad, and then on your handout in red, some suggested language we might use to replace that if this commission's in agreement that it is overly broad. So look at those two and see what you think.
I was really trying to eliminate the word promotes because I think that takes in the caps and the pins and everything, and that's the reason I suggested all advertising regardless of nature and the medium in which it appears, which lists real estate services a licensee shall conform to these requirements. If you're trying to get business, as a buyer's agent or a seller's agent, and it lists that's what you're trying to do, then you got to do these things. But if I'm giving you a cap, giving you a pen, giving you a notepad, I don't think you have to do those things.
Well, I would agree that wording would work better.
We'll get to this, Julie, in a second, but procedurally, if we start making a change to this after the Attorney General's already given his comments or her comments, what does that mean in the process?
We've gotten some comments from the Attorney General.
I can't
I'm
hear you
sorry.
either, I'm sorry.
You're going to have to speak up.
We've gotten some comments from the Attorney General's office, but actually later today, we're going to discuss the main comment that we received back on those rules. So we have not, at this point, they're still at the Attorney General's office. I have to go back with these rules anyway. I spoke with my chief counsel, Michael Driver, about this, and he handles a lot of the rulemaking issues for the various programs and commissions. It was his belief that it would likely not delay too much at this point to make the types of changes that Commissioner Bloom was speaking about, such as deleting promotional materials from this lengthy list, because as it exists, this rule is undertaking a substantial rewrite, and it hasn't gone out for comments yet. Of course, this would be changed before it went out to the public to be able to comment on these at the rulemaking hearing. At the rulemaking hearing, we're limited to changing any rules. It has to be within the scope of the rulemaking, the notice of rulemaking hearing. And what that means, I don't have an exact description, but as I've understood it, it can't go outside of the reasonable notice that someone's gotten. Now, this rule, as you can see, because this is a red line, there was substantial change to this rule that will be noticed. So I think if we wanted to take one or two of these items off of the laundry list, it would be mine and his opinion that it shouldn't cause too much delay in the review process, and that it would still go forward, go out and notice to the public, and they would still be able to make the same comments at the rulemaking hearing. But that would, of course, be up to the Attorney General's office, so there's, no guarantee at this point.
Mr. Alexander?
Well, if I understand all she's just told us, that if we left it until the rules hearing comes up, and we have the rules hearing, then you take it off then, and it would not slow down anything. Is that what you're saying, Julie?
But if it's within, and I think we would think the same case would apply now, that if it was within the scope of this, it shouldn't unreasonably hold this up. But at the rulemaking hearing, you can also make any changes to the rules based on comments or otherwise that are within, I think the language is within the scope of the notice of rulemaking hearing. But you might have some comments on this, and if you're trying to, if it's something the commission already knows that they want to take off, you might avoid 5, 6, 7, 8 comments on this particular topic by doing it for them. That may have been why Commissioner Bloom went ahead and brought this up. So that's up to you all.
Well, I know I've been getting a lot of comments about name tags already, and, people going, well, has the company name got to be bigger than my name on a name tag? I mean, if that's the case, it won't do you any good to wear a name tag. So I have been getting lots of comments on the name tags already, too.
And I don't think we want to necessarily get into our I don't think we want, I think it's on, I can hear it. I don't think we necessarily want to go ahead and get into addressing comments before the rulemaking hearing. We might want to just limit this to what Commissioner Bloom had brought up.
Well, I think name tags kind of fall under that same promotional
But I'm just saying, I don't know
thing.
that we want to do a substantial amendment to this today based on things that people have already brought up, because they will have that opportunity at the rulemaking hearing. But to the extent that you all want to make some changes, I can give them to AG. But as far as what effect it will have, that's up to them. I would imagine if it's within the scope, it would not hold it up. But, I don't know.
So here's my concern, Commissioner Bloom. If there's a car sign, which on its face just has an agent's name and phone number, is that what you're thinking about?
I really wasn't thinking about that. I was thinking about the things that people do to promote their own individual name, like the things that I mentioned, and the pins, and I just see that all the time. People do that, and then I know people spend money for good causes, and they put it in their name. I've seen in Memphis. I've seen a shirt that a person made a big contribution, got her name on a shirt for a 5K run. Why is that a problem for us?
I'm not necessarily quantifying it as a problem. I'm just not sure where you draw the line. Like, what about a bench at a bus stop that just has an agent's name on it?
I think, I disagree with that. I think that needs to be, can you hear me, Commissioner Stevens?
I was wondering how you were talking so loud.
I got it right up here where I can carry it now. But I think that when you take, car signs, they ought to be in compliance. I think if you have an ad on a bench, it ought to be in compliance. But those trivial things, or I think they're trivial, kind of like Commissioner Bloom, should not. That's just like I've got a shirt that says Wendell Alexander Realty. Now, you want me to put all that, the rest of that stuff on, look like?
So the question is, should it have the word realty on it or just Wendell Alexander?
I think either's fine.
Mine says Wendell Alexander Realty, but I don't have the telephone number and the address.
I think promotional items are pretty easily distinguished. I don't think a shopping cart or a park bench or a car sign is promotional.
I think that's advertising.
That's advertising and should fall under the rules.
Don't you, Gary?
I mean, if you want to sponsor a ball team and have your name put on it, I mean, there's probably half the people out here sponsored a ball team or something along those lines at some point, and those are very limited on what you can put on there, and I think those are different.
I'm not disagreeing. I just hope that there's some way you can distinguish between the two topics we have here right now.
I'll say, it's, trying to put a laundry list together of things that Commissioner Bloom is talking about versus the other things. I mean, where do you draw the line?
The word that comes to my mind is incidental. Like this pen is incidental to your business. But a shopping cart might be one of the great ways you advertise. I don't know, and I think we had this discussion slightly last month where we can't find out where the demarcation line is between incidental and advertising. And I don't know the answer.
But currently, in our proposed rule, it mentions promotional materials. I'm going to argue a pen's promotional material.
As is internet advertising, I would think.
Yeah.
Can I make a suggestion?
Yes, sir.
Julie, what would you think about this? Perhaps taking promotional materials out of the sentence that's there and then adding a new sentence at the end that says advertising does not include promotional materials such as, and then maybe people could comment and put together some sort of suggestive list of trinkets and giveaways and inclusion in the logo soup on the back of a T-shirt at the 5K run, and somehow try to put some examples on that as a way to show by example what we don't think is included as advertising.
I think you all could do that, or if you wanted to just take out promotional materials, I mean, I don't know it's up to you all if you would rather add that sentence, because it does say that the term advertising includes but is not limited to, and it can be a case-by-case determination, because really somebody's race T-shirt may be more of advertising to you all based on how it's designed rather than another person's. I mean, you might not want to limit it out, but you could maybe take out that phrase and based on the content of something you receive, determine if you would call it print advertising, because a T-shirt is ultimately printed on the T-shirt. It might be I don't know that you're always going to be able to anticipate every set of circumstances, but taking out that phrase might eliminate some of the immediate questions about caps and pens, and then it just might be kind of on a case-by-case basis, because there could be an infinite number of T-shirt, hat, pen designs, notepads, stickers. I don't know. Anticipating it too much might have been what led us to this point in the first place.
To your point, Julie, we're pretty much complaint driven. We're not out looking for trouble. But if somebody files a complaint based on some promotional material that they think is advertised and is out of compliance, maybe that's the time we try to decide on a case-by-case basis how we handle it.
Well, and the problem is you all can't see complaints on the very front end. I have to describe them to you, which is
well-
sometimes hard. But, taking out the phrase promotional materials, because I know I see what Commissioner Bloom's saying. When you think promotional materials, I think hats, frisbees, things like that you hand out. I know it could be also bus advertisements, but, somebody could just term that a plain print advertisement also, so. Or a sign,
There's, I think, an infinite number of issues. If I sponsor a hole at a golf tournament for the Boys and Girls Club, do I put my company's name or can I put my name on it? Those are issues I don't know that we can make a list.
I'd like to make a motion, we remove promotional materials from, what rule number? 1260-02-.12, number 1.
Is there a second to Mr. Chiaro's motion?
I'll second that, and can I just ask a question before we vote on that?
Absolutely. We're open for discussion.
How can we, or why would we want to monitor electronic signatures?
Well, aren't we breaking those down?
Oh, okay.
We'll
It
get
might
that-
be easier, just for
Yeah,
purposes of your
Let's
discussion.
get this handled. Other discussion on the motion to remove promotional materials from the proposed rule 1260-02, subsection 1.
Other discussion, Chairman.
Yes, sir, Mr. Collins.
Would promotional material include a billboard sign at the football game? See,
Not a defined term. I can't.
well, that's what I'm worried about.
I
We've
think,
already determined that billboards fall under the advertising.
Well, this is a special promotion for a football game coming up.
And that'd be a
It's
sign.
material and it's promoting.
It doesn't
I
say
think
just
it's pretty vague. That's why I was suggesting maybe we could add a sentence that says, advertising does not include promotional materials such as hats, pens, notepads, or, something like that. And that way, that we're not talking about a billboard, which in the vagaries could be considered a promotional material.
Isn't all advertising promotional?
That's why I like my word incidental thrown in there
Yeah, I
somewhere.
think that's,
But I don't know exactly where to place it. We're all working toward the same, I think, goal here. Your point's well made, Commissioner Bloom. It's just how we phrase it. Julie, Austin, will you go back to your suggestion again? Let's just reconsider that.
we could go ahead and vote on this motion and then have a separate motion, maybe to add a sentence if you want to do it that way.
Were you suggesting to take promotional materials out or leave it in and then try to describe
I
it?
was okay with taking promotional materials out of the list, but if you take it out of the list, you're still stuck with the first sentence, which says all advertising which promotes a licensee. You're still left with that as saying that that's prohibited. And so even though you've taken promotional materials out of the list, when there's a new board sitting here in 5 years and none of us are on it, none of them are going to remember that we took promotional materials out of the list, and they're just going to come back and look at this definition and say, well, that pen promotes a licensee, and so therefore it's advertising. And so that was why I was saying, in addition to taking out promotional materials, maybe you want to do something else.
Let's go back to your original recommendation or suggestion and say that again.
Well, you could add a new sentence at the end, in addition to taking out promotional materials. And you could say something like, advertising does not include promotional materials that incidentally advertise, a licensee, such as hats, pens, notepads, or something, T-shirts, whatever, something like that. And then it's pretty clear that obviously you're not excluding billboards by your exclusion that you put in there.
Commissioner Bloom, your thoughts on that recommendation?
That sounds good.
Janet, your motion needs to be amended to add that sentence.
I'm good with that.
Okay, the motion as amended with language, Julie, you've
I got it down as advertising does not include promotional materials that incidentally advertise a licensee, such as hats, pins, notepads, T-shirts, and name tags.
Et cetera.
And the like.
And the like.
And the like.
Yeah.
Oh,
Something.
y'all like that phrase, don't you? Okay. I've got it written down.
Okay,
so
is
I've got that.
everyone clear on the motion as amended? That motion was made initially by Commissioner DeCharo, seconded by Commissioner Bloom, amended in a friendly manner by Commissioner McMullen. Let's vote. All in favor of the motion, please vote aye. Aye. Those opposed, no.
No.
We've got one no. Commissioner Collins, the final tally is 6 aye and 1 no. And at this point, Commissioner Bloom, if it's okay with you, I think we'll take a 10-minute break and come back and pick up topics 2 and 3. 10 minutes, please. Hurry back.
This is a short 10-minute break.
No, it's a 10-minute break.
Yeah, short.
Oh, well, I'll delay this.
They're taking care of important.
I know.
You got another suggestion in that area?
We'll get started here in just a second. Okay, we're back in session. We're on Commissioner Bloom's second item to discuss electronic signatures as it relates to a proposed advertising rule. Commissioner Bloom, will you remind us of your concern about that?
Well, in my limited experience with DocuSign, I don't know how I can make sure that I comply with these rules and regulations. If I have somebody that I'm asking to use their electronic signature and I use mine, I mean, I've got my company name on there, but what if I signed it bigger than them? What if I signed my signature bigger?
You know, I think you make a good point. My concern is, or question, is an electronic signature advertising?
Oh, but we've got it included right there
Correct.
specifically.
Ms. Crop?
What is an electronic signature?
It's when we use the, like DocuSign or DotLoop that we forward to customers or other agents, and they sign it electronically rather than printing it.
What about instead, I mean, this is something kind of different but akin to it. Something that I think we discussed in the past was a problem, instead of electronic signatures, just say email signatures, because that is something, you know,
You're
at the
talking
bottom
about
of an
the block
I
at the
mean, that's
bottom
not
of an email
necessary.
is what you're talking about.
Well, I'm saying instead of electronic signatures, because you're right, electronic signatures would also include the electronic signatures, but you've all expressed, instead of maybe
I just want to make sure we're all talking about the same thing. So by the electronic signature that, or whatever you want to call it, what you're thinking of is the thing at the bottom of an email.
No, I was just saying that's before somebody were to say, take it out or something of that nature, I was going to say that's a type of signature. I think it would be more appropriately called an email signature than an electronic signature. But no, I think an electronic signature could be expanded to be where you, is it DocuSign?
DocuSign, DotLoop, we have several programs available that we use for that kind of stuff, and you can't edit that either.
Commissioner Maxwell, do you have any thoughts on this? I know you do. Would you tell us what they are?
Ms. Crop has expressed my thoughts for me. Thank you. I do. And I have to say, I don't know what was in mind when the electronic signatures was. But I don't know that the commission thought about DocuSign and those types
I
of
don't think we did either.
signatures. I think you. Yeah, I mean, right. I think the concern was email because where you could be creative in DocuSign, those you can't. It's just your
That's why I
signatures.
say you can't do
And if it's
anything.
verified, it has to go through that whole process just as your signature with nothing other than that, and it's verified. I mean, depending on if you use a verified service or not. So, yeah, I think that would be I think that would be difficult, as you all have expressed.
Commissioner Bloom, would you like to offer a motion that removes electronic signatures from this as a starting point?
Yes, I would. I'd like to make the motion that we eliminate electronic signatures from Rule 1260.02.12, number 1.
Second the motion.
Seconded by Commissioner Stevenson. Is there further discussion on this particular motion? Hearing none, all in favor of the motion, please vote aye.
Aye.
Those opposed, no. The vote's unanimous. Now, back to this issue for a second, if people want to discuss it, about a signature block in an email. Is that a different item in your perspective?
I think so.
Any thoughts on a signature block in an email?
I think I can control that. I could not control the
Right.
DocuSign.
This is a great point you made on the signatures. So do we want to address that inside this subsection or let it remain silent?
Well, I think we do need to put that in there so that we probably make them aware of it.
Now, this is an advertising subsection, so do you want to categorize the signature block as advertising for purposes of email, or how do you want to address that? Think about it.
Lee, do you have any thoughts on that?
I think if you want to specifically address it, the easiest thing would be to just change the word electronic to email signatures. I mean, it's called a signature within Outlook, I know, and at least within Outlook, you can go in, you can change the font, the size, it's completely
You can
color.
on most email
And
programs,
so, I
I
mean,
think.
I think the correct phrasing for that would be email signature, but, I mean, it's at the bottom of emails, so.
I got it.
know.
You can blow anything up you wanted to on that, add any logos.
But
So-
I think that would be the right phrase for it. I mean, I don't have another suggestion, but someone else might.
Like to make that a motion, Mr. Charles, so we can get
I
on the floor
would.
to discuss?
I will make the motion that we change, or that we add email signatures in the place of electronic signatures.
Okay, so thus far, we've pulled electronic signatures out of this document. Your motion, if we get a second, is to add email signatures.
Correct.
Is there a second to Mr. Charles' motion?
I'll second that.
Seconded by Commissioner Bloom. Now, is there additional discussion on the motion? Hearing none, let's vote on that motion. All in favor, please say aye.
Aye.
Those opposed, no. It's unanimous. Thank you, Commissioner Bloom, for number 2. And now, number 3, social media communications. Please refresh our memory on your thoughts on that.
I'm not maybe the one who would know that much about it, but I don't think that you can monitor all social media communication so we'd know if somebody was in compliance with our rules and regulations or not. Or should we care about that is the other thing.
Well, I would like to address Facebook particularly. Every morning when I open Facebook, there are violations all over Facebook when it comes to real estate. And I think that's fairly easy for us to monitor when it's in our face every day. Tweets are a different thing, but we did put a policy in place that said it has to be, all your information has to be one click away, so they should use a link when they're advertising a piece of property. And there are many forms of social media.
So, I don't know that it's the responsibility of the real estate commission or staff to necessarily monitor it, but if somebody files a complaint based on a Facebook posting, that's another issue that's a little bit tricky for council because they don't want to show us the example because it influences our decision. But I'm fairly certain, like on Facebook, if somebody says, come to my open house this Sunday, it's a beautiful rancher somewhere, do you believe the real estate company's name should be in that advertisement?
I do.
Other thoughts about that?
Me, I'm grandfathered.
You don't. You You're grandfathered in what respect?
I don't do those things,
Oh, you don't use Facebook. It's not an issue for you.
and I don't tweet.
You might tweet someday. Is there a desire to amend this language to reflect a new thought regarding social media?
I think when we initially did social media, and Austin helped refresh my memory here, that we left it as social media so that we did not have to name every one of them because there was so many new forms coming out all the time.
So the chair will ask again, is there a motion regarding social media that one would like to make at this point? This does not preclude us from making a motion at some future date, obviously. Hearing none, thank you, Commissioner Bloom, for your concerns, and we'll move on the agenda. Principal broker audit, Ms. Maxwell.
I just wanted to update you quickly on the principal broker audit forms. As I said last month, on May the 19th, we sent 191 letters to randomly selected firms across the state in our first mail-in audit, and got really good response. I mean, a lot of firms spent a lot of time sending in many, many documents, and we have now, at this point, about 180 reports that have come back in, and then 5 have been returned. So we've got just about everybody that and then a couple of firms had closed and it wasn't reflected, and then several had waivers so that, they just responded, but they didn't actually have to fill out the audit form. So we've gotten we've gotten responses and answers and completed forms from almost every firm that we sent the form to. So I think that was great, and we unfroze the auditor position. And so that will be posted today. It should be posted today through Tuesday of next week. And so it'll be posted, and then we'll get a list of individuals who are interested in the Auditor 2 position so that we can start the process of going through those audits that we received and seeing if there's additional information that we need, or if the firm might need a visit, or some follow-up as far as that goes. So the first process and the first launch seems to have been pretty successful, and as I say, the response was very good. Most of the principal brokers, I got a lot of questions from principal brokers, but they seemed very, they were concerned about making sure it was done properly, and I think that was great, because I didn't know what to expect, at least. And Julie did add the language that the commission wanted in the new cover letter to advise individuals that if they don't comply, that they could have penalties up to $1,000. So that's been included in the new letters, and we probably won't send another wave of letters out until we, actually get someone hired, which will be in the next. It should be in the next 3 to 4 weeks if anyone comes. If we interview someone who, works out for the job, when the interview should start, which is probably about 10 days. So that's just an update.
Ms. Maxwell, did you remove the part where there had to be a CPA?
They do. We did make it an auditor as opposed to an investigator, but I asked, so they had to have 4 years accounting or some experience that would be equivalent, 4 years of college education accounting, or the equivalent experience. I did add some additional questions as to forensic audits and any experience with real estate audits and things of that nature, so that we could hopefully narrow down the list of individuals and I asked about investigative backgrounds that any of the applicants might have. So hopefully that'll narrow down our field and get some people that have both skills, because the person will still go into firms and make spot checks and investigate questions that the commission might have about a complaint, or the legal department might have about a complaint. But as I say, we have gotten some suggestions about the form where it might need to be clarified. So I think we'll probably wait for another round of the letters just to see what, additional comments or suggestions that we might get.
Ms. Maxwell, I thought that in that form, we had changed it where it said trust account / escrow account. But I had a call last week on from a broker that said, I didn't realize I'd been doing this wrong all the time. My account said escrow account and not trust account, so I went to the bank and had everything changed and have ordered all new checks. And I said, that's not necessary. I said, it can be called trust account or escrow, and he said, not according to that form.
The form actually, the trust account is a defined term. It says it includes escrow security, earnest money, and it lists every.
Well, I
sort of
thought we had
name.
changed that.
Because we decided to make it a trust account a defined term, which is used in the statute because it's more encompassing than just using an escrow account. And so, but they're all included right there in that definition on the cover sheet. And I did have a couple of people ask me about the trust account, and those particular people that asked me had gone to the bank, and the bank said, well, no, you can't really have a trust account because a trust account is an account set up under, all the rules with like a generation skipping trust or, that sort of a trust account, and that's a totally different trust account than what you're talking about, which is an account, for the benefit of holding third-party monies. So if there, so it is a defined term on the first page, and it is, I thought it was clear. It must not be clear because I did get some questions as well. So that might need to be changed to something that.
I would say, when Michelle and I initially
Right.
did the audit, that was comments that both of us
Right, that you all had.
Had.
And then a decision was made to define that term, which is defined on the front page, and it includes security deposit and trust and escrow and earnest and any other names. And as I say, the trust account is used, trust is used in the statute as well, but it did seem to lead to some confusion. And most banks said they couldn't, it's the people that I talked to, the bank told them that they couldn't set up what an account designated trust in the sense of, that the bank uses that term. But the intent was never, if it's confusing people, they go out and buy new checks, and that's definitely not the intent of that at all. Maybe a sentence needs to be in there that clarifies that it doesn't have to have that name, like that.
And I think we need to do
designation.
something to
So that they don't end up in
clarify
that.
it some.
Yeah, so that they don't end up doing something like that. And there, as I say, there were two or three questions that kind of, or, suggestions sort of popped up consistently that, need to, like, as I say, I was going to send it through one more round just to sort of see if those same things came in and people had questions, but that's something that's easy to, easy to fix, and make it clear that they don't need to do that. Because, that's not what we're trying to get people to do. We just want to make sure that it's designated properly.
Julie, didn't the Attorney General's comments on our proposed rules, he was pretty adamant, or she, about trust accounts and struck just about everything else. It looked to me, if I read the comments correctly, or the red line.
Nothing altered with the AG's comments. That was a red line based on how we've
That's
changed
how
the
we
rule.
did it. And we've identified it as trust accounts at this point.
You all voted to change that wording. The red lines, the things that were underlined and stricken through, were things that you all had changed.
Thank you.
Nothing that the AG had noted.
So-
When we made some changes to the earnest money, the rule already now entitled deposits and earnest money, you all wanted to consistently refer to them as escrow or trustee accounts throughout that rule. And so that wording change is based on what you all voted to do when these rules went through.
Thank you. Other comments? All right, Ms. Maxwell, training program.
Yes. I sent each of you all an email that referenced a public chapter that was passed and enacted into law that requires each regulatory board to come up with an apprenticeship or training program. And in the public chapter, it lists a number of items that the plan should include but not be limited to the subject of. And those were apprenticeship training, supervisory standards, occupational instruction, wages and benefits, licensure, and the role of the Division of Regulatory Boards in implementing and maintaining the program. So Julie and I talked about it and thought that the commission was probably the best source to maybe have some suggestions or give us some guidance. Just because I've asked for this doesn't mean that it's going to be implemented. It's just, they've asked every regulatory board to do this. So, and it has to, and it'll be submitted to the governor, the Speaker of the Senate, the Speaker of the House, the GovOps Committee, and the Commissioner of Commerce Insurance, and the Commissioner of Health and Commissioner of Labor. The health departments are doing it as well. So it's a broad-based sort of apprentice program, and as I say, we just wanted to see if y'all had any suggestions about it. And Grover sent some suggestions. But we're, as I say, open for.
Is the apprentice program to be inside a real estate firm? It's not inside the commission office? I mean,
No, I believe it would be inside a firm, sort of like, is it do auctioneers have an apprentice, something sort of akin to that?
Right,
So,
we have a
like,
2-year apprentice program.
Appraisers do, and
So it
home
would be,
inspectors.
I guess it would be something sort of, I mean, it doesn't have to be like theirs, but it's something akin to that.
A good time to do away with the two-tier license and let them serve an apprentice, and then everybody be a broker.
In theory, the affiliate broker is that's designed during that time period that you're an affiliate, but then you can be an affiliate for life.
Commissioner Collins, you want to repeat your comments that you emailed to us?
Well, it's been 2 days. I probably forgot most of it.
We have too, so.
Well, anyway, I was basing when I first started in the real estate business, before you could stand for your broker, you had to serve a period of time working under somebody, and just like the auctioneers. And I think it's a good program, so it eliminates people from jumping in and jumping out just to see if they like it, to see if they can pass the test. They're doing another job, and they say, I think I'll try real estate for a week, and it clutters up the whole system. And I think if they knew they had to serve a 2-year apprenticeship under someone, they might become more into the program than just jumping in, jumping out. I think it'd save everybody a lot of money and time in policing the system. And I think I'm glad the state came up with that idea.
Well, didn't you, years ago, Grandpa down there, have to have a sponsor to get into the real estate business? Didn't you have to have somebody to recommend you?
Yes.
And it's kind of going back to the same kind of thing is,
No, you have to have a broker, and you have to have a broker now.
well, no, back years ago, you had to have not necessarily a broker, but kind of like a mentor that was going to
I'm not
be
that
willing
old.
to. Well, that's why I asked Grandpa down there.
And that's
I believe
why-
I've
I can
been-
give you an answer. You had to, before it used to be, before you took the exam, you had to have you had to tell them who the broker was going to be. In other words, you didn't just go to school, take the exam, and then find you a broker. You found you a broker before you started. But I could see where if you have the apprenticeship and you don't have any license, you'll have some folks that just, like you say, that the affiliate broker was the thing for to get their experience before you get a broker's license. They'll never take the test. They'll just keep working as an apprentice.
Well, I had, last year, I started a training program in my office in like November, and they had to go through 6 months of training. And I had some people who were considering getting their real estate license. And after they went through the training, they decided it was way more work than what they wanted to get involved in. So, it might eliminate some people if they realized it's not just drinking coffee and running up and down the street.
So did you pay those people? Like,
No.
So they did it gratis for free?
They came because they wanted to come to work for my company.
Uh-huh.
And so I had a 6-month training. Some of them had already passed their test, but some of them were looking at getting their license. And after they came to the training, they decided it was way too much work.
Well, did you have them do like ministerial work? Like what? Like did you just teach them, or did you actually have them like do work? Or
Oh,
what?
no, I made them go out and measure houses and things of that nature. We went out in the field and measured houses and actually made them work.
And Janet, did the thought ever occur to you they just might not have wanted to work for you?
That's okay, because if they don't want to do it right, I don't want them working for me.
So Austin, if you know, under the new court, the court rulings that basically have kind of made it a little iffy about people working for free, interns and apprentices, and do you think that would be problematic?
I'm not familiar with those.
I mean, we don't get,
The only people I know working for free are the ones who file bankruptcy, so I don't know.
I mean, we're all 1099 people anyway, so
Right,
none
no,
of
I
us
know,
get
I
a
just-
salary, so.
Yeah. And so they just came because they signed, like, how many people did you have?
I had 10 when the class started out, and 4 of those became agents.
Or did you think that was like a manageable number?
Mm-hmm.
And you sent them out with another person in your firm to go?
No,
do
I
the-
went with them.
You went with, so anybody that went to measure a house or do the other things, you went with them?
I mean, we've got lots of vacant houses, new construction, and I just
Right.
call the other agent and say, hey, I'm bringing the whole crew over, and we're gonna be measuring and hanging around your house like monkeys.
Kind of like
So-
you used to do in the old, like the old
We
classes.
do an
Oh, real estate
hour,
classes
we
you
did
used to
an
do.
hour a week for 6 months.
So they met just with you for 1 hour, and you went on a field trip and did a measurement? Or
I mean, sometimes we were in the office
Right.
studying dot loop or studying contracts or whatever.
And did you think that was a sufficient time? I know, obviously, it was for 6 of them to decide that wasn't their deal.
Well, and then the 4 who came to work for me, then, of course, I go with them to list and
Right.
to show properties after that, but
Did you take them
And
to
them
closing?
4 still around.
all of them.
They're good at measuring houses now.
That's right. They know how to measure a house and write a contract.
Kind of contract.
You don't want to know, because we use TAR contracts in my office.
Do that. That's right, and there's some messed up when I get them.
Other comments, so I'm confused, Janet, or anybody that wants to speak to this, in an auction, an apprentice auctioneer, have they already passed a test?
He don't know.
Yes. I'm trying to think.
Maybe.
He doesn't know.
I don't have any apprentice auctioneers right now, but I'm trying to think.
So they
I
already
mean,
passed.
they have to, I have to sign for them to take the test. They have to have a master auctioneer that they're going to have their apprentice auctioneer's license with. I signed the application.
Yes, they've passed the test.
They've already passed a test. Will they have to pass a second test at some point?
I don't
to become
think
an
so.
auctioneer?
Yes, there's a
Do that, I don't know
separate
about-
test.
So my question to you, Janet, and I'm just posing these questions, is what comes first? Do you want to make sure somebody can pass a test before you start putting them into a program that is defined as an apprentice program, whatever that is? Or do you want to start seeing if they like the business before they take the test?
You can't take the test until you've got the education, or part of it, can you?
No, you can't.
I still comes back to my original thought, that it'd be a good way to do away with affiliate brokers and have
I agree. One license.
one license, and then have trainees that have been educated and taken the test, and then take the principal broker's test after 2 years, or 3, whatever it is, 2 years now, ain't it? Gotta have 2 years of training or under a principal broker before you can take the principal broker's.
3 as a principal broker. You have to be licensed for 3
As a
years.
broker, I didn't mean principal broker, I mean broker.
It was 3 years.
Just as, to follow up on this discussion, I think that at least our initial goal is to give staff some guidelines they can submit back to various state government entities. Do you see any urgency in this legislation as far as brokers within a year or two having to start doing this?
Well, I don't know.
We just have to have the
We just have to have
plan
the plan.
submitted by December 31st.
There is a sense of urgency about the plan. Whether it'll go, beyond that, neither one of us
At
really
this
know.
point, it only says that there's the requirement that each commission submit a plan. It doesn't go beyond that, and we don't really know anything beyond what this legislation states. So what we're trying to do is just make sure, my role is to make sure that the commission complies with this requirement that's been imposed on it. And even I tried to pre-brainstorm to come up with some ideas, and really what we're looking for is we need the commission to give us direction on what they want what you want your plan to look like that we submit for you.
Will next month be soon enough?
I think we can do that.
I mean,
We
just
can discuss it.
based
Yeah.
on the discussions that we've had,
It doesn't-
we can think about this and come back with, next month, come back with some
That's
ideas
fine.
as to what you think would be an appropriate type of apprentice program.
And that would be
training
workable
program.
that you all think would be workable and could be implemented
The
without.
problem that I have is that it would be workable.
Right.
Is the commission going to dictate to me at ABC Realty how I train my agents? Are they going to say, here's a program that we have for you to get people started in the real estate business?
We don't really.
I don't see where it has a
yeah.
place in our industry. I really don't.
All that we have is that it just says that we have to have a plan to create an apprentice program for use by such boards and commissions. And one of the considerations is the role of the Division of Regulatory Boards in implementing and maintaining the program.
Yeah, so how are we going to implement and maintain this apprentice program for ABC Realty in Memphis, Tennessee? I don't
considerations that we
see
need
it,
you
I
all to
really
come
don't
up
see it has
with.
an application in our industry. I mean, we all work for fees. It's not like we could hire somebody and say, oh, you're my apprentice here, and here's how much you get, and this is what you've got to do. We all have programs for all of our agents already. Hopefully. I mean, that's the role of the principal broker that we're trying to manage. I'd be offended if the commission said, here's what you have to do for every new hire.
I understand what you're saying, because when you don't work for money, it's hard to, like, you're only going to
You're
make
right,
money
I
if you
don't work
sell.
for money.
Right,
I wish I did. Now, about
you're only
7
gonna
years
make
ago,
money
I
if you
worked for
sell.
money.
Right, but you're only going to make money if you have a transaction that goes to closure. And so it's difficult to bring someone on to train for 2 years if they,
And
they've
if
got
we
to be able
spend a
to
lot of
do
time
something.
manufacturing this program, how are we going to monitor that? And how are we going to see that ABC uses it? And why would they use it?
Right, and I think that, we don't know much about the intent behind the legislation. It's just that,
I'd like to make a recommendation, we take a pass on this.
I don't think we can take a pass. I don't think that it's a statute, we have to,
Where did we get to the point where we said we weren't going to pay them? We would pay the apprentice.
Not my house.
No,
You wouldn't?
We can barely afford at this point to
No,
have
you can't.
secretarial help. I can't pay somebody who may or may not come to work on a commission basis.
No, I mean on a commission basis. What's the difference?
Who introduced Senate Bill 2053 anyway?
Be live.
Bell.
Lynn?
That's the bill number.
Yeah,
The
it's
Senate bill
Lynn,
number.
Lynn is the,
Who?
Lynn is the name on here.
House is Lynn, Senate is Bell.
Oh, yeah, I'm sorry, yeah, House is Lynn, Senate is Bell.
Senate is Bell, House is Lynn. I was confused by the bill. To me, it was confusing whether it was talking about the Tennessee Real Estate Commission would have apprentices or if the licensees would have apprentices.
yeah, I think it's that the licensees will have,
Makes more sense, but the way it was written, it was
it is kind of.
pretty vague.
yeah, it was kind of the same
Yeah,
way.
and I think that it means that the licensees would have apprentices, because, then it talks about the programs that already have apprentice programs in place, and they have to report on the success, and the second part of the bill requires
Talks about
that.
implementation
But
and
there-
maintenance of the program, but
Yeah.
as it says up here, for use by such boards, I see what,
Well,
Have any other boards or commissions come up with apprentice programs?
auctioneers and appraisers, aren't those, I think,
Are you talking about
Home inspectors
affiliate
have
broker
appraisers.
having,
I mean, the Prentice program, it's like it's an open tablet, you can write whatever, I mean, it's the commission can write whatever they think would be a program that would be workable and could be implemented in the business and would maybe better train licensees. As I say, similar, I guess, to, or like what you all have in auctioneers or appraisers have, and I think that's the only, did you say home inspectors?
Home inspectors have.
My suggestion was going to be if there be any benefit to looking at the other apprentice programs that are already out there and seeing if there's something that we like there and just adopting it rather than spend a lot of time and effort to come up with something completely new writing on a blank tablet.
I like the auctioneer program, personally.
yeah, because the auctioneer, just briefly, Grover, if you want to add anything to this, but if I do sponsor an apprentice auctioneer, it's a 2-year apprentice program, and during that time period, they have to accumulate X number of points. Working at an auction, they get, I think it's like 20 points. And if they auction at the event, call bids, they get, I think, 30 points. If they, develop a brochure, there's different ways that you can earn points, and you've got to have a total of 1,000 points before you can take the test at the end of your 2-year apprentice program. You have to have a minimum of 1,000 points before you can take your master auctioneer's exam and become a master auctioneer after you finish your 2-year apprentice program. I mean, you can be in the apprentice program 3 years, 4 years, but it's a minimum of 2 years. But I mean, that's just the kind of things that within the auctioneer apprentice program that occurs.
There is a rule in the auctioneer commission's rules, and I can give you the rule number, or I can email it out to everybody separately after the meeting if you wanted to take a look at it. It outlines the point system and the program if you all wanted to take a look at it before next month, because they do have a rule that talks about what an apprentice may and may not do, the point system.
That's written in the law?
They have a rule. Mm-hmm.
It might be good to have.
I could
Julie,
just
if
send
you
it out
email that
separately to
us.
everyone and just, and whatever else I can find, I can look through the rest of it. But that apprentice rule is about 2 pages long, so it might be a little bit helpful for next month, and I could send it out. But it addresses what Commissioner Stevenson's speaking
If
of.
you're in the auctioneer business, you can't do absolutely nothing and become an auctioneer. And that's the same with the real estate. We have people that are in the real estate business, are affiliates for 10 years and work somewhere else and never go to the office. What training do they get? What proof do they have any training? Then we have some others that work their tails off and become great real estate agents, whether they ever want to get their brokers or not. But there's some point what they have to achieve before they can be a broker. It's what it's really, to me, it's saying.
Is that in our purview, or is that legislated?
That's legislature.
So we'd make a recommendation to the legislature.
Well, to the governor and different branches of government.
They're asking us to do that.
I can send out the rule. It references the apprentice log and the proof that the apprentice for an auctioneer apprentice would turn in to show their work experience.
So this
Might be
takes
some helpful.
the twist of a license requirement, not a requirement for an existing company as to what we would say would be an apprentice program for ABC Realty.
We really have nothing more than what you all have with the.
But what we're
public
talking
general.
about, the auctioneer,
The
it's a licensing
It's a
requirement.
license for the auctioneer.
And are they asking us then to create a licensing requirement?
It's so vague. But this is really a two-part problem. The first part is staff has got to respond. They don't know how to respond. Neither do we at this point. So they've got to get a response in. And then second of all, how serious do we want to take the response as a commission? Because you're asking good questions. Grover's making great points here. But at the end of the day, how do you tell a broker to keep track of points? Why couldn't they just say he's got 1,000 points and he's in? And I don't know how we ever get to that level of detail. But the initial step is to come up with something that the staff can submit. And if it's just mimicking the Auctioneers Commission, at least it's an effort to comply with the legislation, which is as vague as anything I've seen. I agree with you, Austin. I thought it was referring to the commission
Did too.
itself and not individual real estate offices. It's that, but poorly written, in my opinion.
Did TAR talk about that? I feel like in 2006 or something, Commissioner Northern had a document from TAR Treef that talked about like apprentice or mentor programs or.
There's been some conversation about mentor programs and helping develop those, but I don't know that it ever went anywhere.
I just kind of feel like it was some document, but it was like from 2006. It was a pretty long, it was the document itself.
Maybe Mr. McDonald can locate that.
Maybe he can.
for
I
us.
might have it, but maybe he can. I didn't know if either you or Gary or someone else remembered talking, that being a point of discussion.
Something we could consider next month that might address some of the concerns you all have had is, the plan doesn't have to be limited to this. We can add a 7th section of the Commission's opinion of practicability of such program where you all can include your thoughts on, well, here's our plan that we're required to submit, but this is what we really think in terms of our industry. Because you're not limited to just these things, and that way we comply with the requirement of reporting this information, but you all get to let them know what you think of the practicality of using this in the real estate industry.
Other comments on this topic? Let's move on, Ms. Maxwell.
We'll try to get some things and send them to you all over the next month, and hopefully that'll be better. The next point on the agenda is the commission meeting schedule for 2015, which we've been asked to create and approve this month if possible. And Kimberly had put together just just suggested dates that worked out, and it's on the iPads. Of course, I don't have mine on. And
Eve, have you checked these along with the Arillo conferences?
you'll see on the document that's in front of you, my thing is, you'll see that has like the time for the Arillo conferences, and it's got the National Association of Realtors conferences and the Tennessee Association, I believe, on there, so that you all could see those and see where they fit in to the schedule. And as I say, it's just trying to make it work out roughly every 4 weeks for 2015. And then make sure that you still want the hearings, the ALJ hearings, the formal hearings on the second day, like we've set it up this year. The ALJs apparently are ready to schedule their time. Everybody find it on their iPad? I would tell you where it is.
For discussion on the calendar, if not, is there a motion to accept this calendar?
So move.
Thank you, Mr. Bloom. Motion to accept the proposed 2014-15 TREC calendar. Is there a second?
Second.
Is there discussion? Hearing none, let's vote. All in favor, vote aye.
Aye.
Those opposed, no. It's unanimous. Thank you, Ms. Maxwell.
Do you have any feelings about where you would meet in the east and west, or do you want to just kind of reserve those to be announced?
We should put bids out, don't you think, and see
Who wants
to
us?
see who wants us badly.
Well, okay, we can do that.
That'd be embarrassing. Nobody might
I
respond.
know, that's the problem.
Then we'll just have to invite ourselves. And then do you want to keep the ALJ, the formal hearing scheduled for the second day like we have done this year?
I think that's worked out well.
Yeah. Any other comments?
Okay, that's good. The next item is just an update on the fingerprints, and just to sort of let you know where we are. We've had 2,138 applicants who've been fingerprinted between 1/1 and 6/30. The number that have come back with indications, which again means that they had something that showed up, whether it was a charge, conviction, just anything that showed up on their report that came back to us, is 428, which has remained constant at about 20% since the first of the year. The number of reports with no indication, which means they had just a clean report that just had their name, social security number, and that nothing else, basically, was 1,654. And then 56 people have had to get their prints read again because their fingers, it just didn't take. And most people's work on the second time around. The fingerprints seem to be going a little bit smoother. Most people are seemingly getting them done before they start the process of classes, or at least midway through the classes, so that the fingerprints and the test results usually come in close to one another. Some people are going ahead and getting court information. If they know that they've got something on that's going to show up on their report, they'll go ahead and get the court dispositions so that we have those, and not, have to spend some additional time trying to get dispositions of things that appear on their FBI report, FBI TBI reports. So as I say, that seems to be working out well, and there are not as many issues with it, I think, as there were at the beginning. People know they have to get them done now.
Questions? Next item.
The next item is the budget, which I sent to you all. I didn't know if does anyone have any questions on the budget? It's the May 2014, and next month, hopefully it'll be the June 30, the year-end closed budget, but this was the May budget. So the next thing on the agenda is Arello, and last month when we talked about it, Commissioner DeCharo wanted to go, and then Julie was going to ask to see if it was okay for her to go, at least with her doctor. And so we needed to vote on who was going to go, so that there's a motion and a vote taken that we can put in the justification who's going to go, and clarify that.
Well, I have a question before
Okay.
we do that. Is there any body that we're looking at this point for Steve's position, so that's a person we need to send as well?
I asked Bill about it, Bill Giannini about it on, what's today, Wednesday, Monday. And they're still looking for someone. So probably not that we could add in the justification at this point, because we have to identify a person, and that makes it difficult. That's not to say that there won't be someone hired by then, and, maybe we could amend it. Maybe somehow you can amend it, but right now, we would have to have an identified person to put in.
So we
there.
can't just
You can't
put
just
it in
put-
as education director?
No, I mean, you have to have a person, like a real person. So it might be, I'll ask again, but when we asked before about that, we were told, no, you actually had to have a person. You can't even switch people out, like, just, even if your information were identical, we can't switch you out, your identification as far as flying and, the mileage and things of that nature. But I'll ask again to make sure before we turn it in, and confirm that that's the case. Because if we could do it, we could just put it in as a placeholder, or that name is a placeholder.
Julie wanted to take her doctor, is that what you said?
I don't want to take my doctor.
Did he say it was okay, Julie?
Yes.
So anyway, so now, as I say, what we need is the commission needs to make a motion as to
So-
who will go, so that I can put in the justification that you all made a motion and approved the, people to go.
Carol entertained a motion to that effect. The number of people we're talking about at this point is three?
It's three, and I'll ask whether we can just use that title as a placeholder.
Which conference is this?
It's the
Arello.
Arello Conference. Do you want to go? It's in Philadelphia.
When is it?
Oh, it's September 17th through the 21st. It's a Wednesday through a Sunday in Philadelphia. Would you like to look at the schedule? No.
I was just curious which one we were talking about. That's good. I will make that motion for Ms. DeChara and Ms. Crop.
And Ms.
And
Maxwell.
Ms. Maxwell, yes.
I've got a second, a motion made by Commissioner McMullen, seconded by Commissioner Collins, that Ms. DeChara, Ms. Crop, and Ms. Maxwell be submitted for approval to travel to the Arello Conference in September. Is there discussion?
I'd like for them to send us an email report.
Well, how about if it's handwritten instead of email?
I'd rather have it emailed.
What if they'd make a verbal report?
I'd rather have it emailed, so if I don't like it, I can trash it. I don't have to listen to it.
I'd like to get a cheesesteak back.
I'd like to see the flyers.
Well, I was going to say, I think you want one of those ladies to bring the cheesesteak, because by the time you see me, it probably wouldn't be good.
We'll take that under advisement if it gets approved.
All right, you all have heard the motion. Let's vote. All in favor, please vote aye. Aye. Those opposed, no. It is unanimous.
And just so the next topic is the William Bill Toon Award. And as you recall, at the June meeting, the commission voted on two things as it relates to the Bill Toon Award, which is established by Commission Policy 96-CPS-004. The first item that the commission voted on last month was to award the Bill Toon Award for Excellence in Education to Pug Schofield, who has recently retired from the Tennessee Association of Realtors. And we I think the commission sort of left it that he's left town and maybe he would be able to come back at some point. The Tennessee Association of Realtors, their education director indicates that they might be able to assist in, the payment for same or arrangements as it relates to that if the commission decides they want to do something more than a plaque or, wants to do something. That same individual thought that Mr. Schofield would be returning to Nashville or to Tennessee for a wedding sometime in the fall, in September. So I don't know whether the commission wants to make more definite plans or, but just so that you know that.
Chairman,
Mr. Alexander.
I move that we appoint a committee of one of Commissioner Bloom to handle this with proper folks if we want to do some more. And I think they'd like to do it.
I'll second that.
Well, I'd be glad to do that, but I thought we did that with Grover last time. Did we not?
Do you recall that motion, Mr. Collins?
I can be recalled, that's okay.
What?
So,
It doesn't matter,
Did
whatever.
we already have a committee?
Yeah,
Well, I'm sorry about that.
that's all right. You just recalled me. And that's all right.
Why don't, the motion dies for like a second? No.
no, we had a second, but I understand it was withdrawn. So I think that's
it
okay.
was.
Yeah, my motion's withdrawn too.
Yeah.
I'd like to make the motion then, that we let Gary handle it.
Well, I want to amend that motion and put you on that committee too.
That's a committee of
We
one.
can't have
No,
two
one
people
person
at
can-
Sunshine Law.
I'll withdraw my motion. I'll work on it.
Okay.
Okay, so anyway, that's some additional information as it
And
relates
I
to
hope
that.
you'll,
Work out with our September meeting.
I have no idea.
I hope you'll convey to the Tennessee Association folks you talk to that we appreciate them paying the cost of it.
I intend to.
Well, thank you.
I did hear that from their education director,
understand.
not from.
I think they'd be
Oh, they'll do
honored
it.
to.
Just want to make sure that you do that. And then the second thing that the commission had voted on last month was that as commissioners retire in their terms, that each one would be given the William C. Bill Toon Award for Excellence in Education just by nature of a certificate. The policy itself says that number one, that no more than one award will be given during any one-year period, and the commission may decide not to issue an award if they so choose. So I don't know if the commission would like to amend the policy 96 CPS 004 to allow more than one award to be given during.
I make a motion, we amend it,
Okay.
because some years we haven't done anything, and some years we have, and we even had to back one up when we did two one time, and put one in one year and the other in the next year, so let's eliminate that and not have that problem.
I've got a motion by Commissioner Collins to remove the cap on the number of recipients annually for the William Toon Award. Is there a second to that motion?
Second.
Okay, this refers to a policy that's currently in place. So it's been moved and seconded that more than one, the effect of this motion is that more than one person in any calendar year can receive the William Toon Award. Is there discussion about the motion? Hearing none, let's vote. All in favor, say aye. Aye. Those opposed, no. It's unanimous. Thank you, Mr. Collins.
I'll work on amending that over lunch for your signature afterward.
Who seconded that motion?
Mr. Bloom,
Okay, thank you.
let's get the education report in.
Did you say skip it?
No, let's do it.
Oh, okay.
Let's do it.
The education report, The first item that's on the iPads are the courses presented for commission evaluation. And as you can see there, 13 courses that I reviewed and would recommend to be approved with the instructors that are listed to the far right side. There's one course, J14, that I thought the commission might want to discuss, and are there any questions about any of those? None of them deal with reverse mortgages.
Can I ask about course J8 just for a second?
Huh?
Now, when it says previously approved, does that mean in a previous accreditation time period? What does that mean, previously?
If it says previously approved, it refers to the instructor. And the instructors have, every 2 years, just like the courses, they have to renew. They have a form that they fill out, and on that form, at the bottom, it lists all the 17 areas that CE can be offered in, or, fall under one of the categories. And then it also lists pre-licensed office broker management. And so they can check all those disciplines that they think that they are qualified for, and we review their qualifications to see if, in fact, they are qualified to teach those items. And so this individual has been previously approved to teach a course, and then is previously approved as far as his credentials go to teach a course that would be related to the commercial real estate negotiation skills. And so that holds true for the individuals that you see that say previously approved, and then the other individuals who are listed with the courses have not been previously approved. And then when this year ends, all these instructors they'll have to fill out another form when they're going to teach the course here. So, and one of the commissioners is listed as a teacher in one of the courses.
These previously approved.
J2.
Yeah.
On J14, it says branding to HER. Is that like to females? Is that a female course?
Yes, it is, and so that's the one I have under discussion, because not because it brands to females, but because it just, it's really a pure branding. I mean, it really is just a pure branding marketing course with, it just didn't seem like it had a whole lot of relevance to real estate. I mean, it was, and it was really
Just didn't
based-
justify continuing education.
I mean, I didn't think it did.
Sounds like a dating class.
It was, at first I thought the HER stood for something else, was an acronym for something I wasn't familiar with, but it's not. I mean, it wasn't. And as I say, it's not because it just markets
They
to
denied.
female. It's really what it's based on is that the female makes all the decisions in the household, or the largest majority of the decisions, and so that you should aim your marketing at that person who is the primary decision maker in the home. And so that was really the premise of the course, and then it's only a 2-hour course, but then it does go through some theories.
For fear of being branded a male chauvinist, I will second Commissioner Alexander's motion to not approve this course.
Let's
Can I make a motion to approve J1 through J13
Yeah,
first?
let's get a positive motion here to start with, if that's all right with you guys to wait just a second. The motion by Commissioner DeCharo is to approve courses J1 through J13. Is there a second to that motion?
Second that motion.
Thank you, Commissioner Stevenson. Is there discussion on the motion? All in favor of the motion, please vote aye.
Aye.
Those opposed, no.
Mr.
It's
Chairman,
unanimous.
Mr. Chairman,
Yes.
McMullen abstains.
On all of them, or you want?
Yeah, all of them.
Okay. 6-0-1. Commissioner McMullen abstains.
Mullen in those again?
Mr. Alexander was nice enough to let us defer his motion for a moment. His motion is to deny approval of course J14, and that was seconded by Commissioner Stevenson.
You want my reasoning?
I certainly would.
I'm going to take the advice of our learned executive. She felt like it was not what it should be, so therefore, that's what she gets paid to do. That's my reasoning.
It's good enough for me.
Good enough for me.
And that's the reason I seconded it.
All right, so we're putting the whole onus back on the executive director.
Hey, well,
Got broad shoulders.
Let's vote. All in favor of Commissioner Alexander's motion to deny approval of this course, J14, please say aye. Aye. Those opposed, no. It's unanimous. Ms. Maxwell?
yes. The next item, we didn't have any additional instructors this month, I don't believe. The next item was instructor qualification. And I'm asking this question because I don't know whether it's happened in the past. I don't recall it, but it could have happened. There's an individual who wants to teach a pre-license course. That individual is licensed in Kentucky as a broker and has been for a number of years. It is a Internet Arello certified pre-license course, the 60-hour pre-license course. So it's it's Arello approved. He's an IDEC instructor that's been trained through Arello. The question is, since he's not a Tennessee broker, he's not been a Tennessee broker, he's always been a Kentucky broker and a few other states. Is it the commission find it acceptable for that person to teach, or a person who is like that to teach the pre-license course? Because they're not, I mean, do you have to be a Tennessee broker to teach the pre-license course?
What are their qualifications as far as teaching Tennessee law?
The individual lives very close to the border, and so he, has familiarity with Tennessee law. He has been approved to teach a core course, and he has been a broker, as I say, for over 20 years. And, he's been a principal broker off and on, not of a Tennessee firm. So, I mean, I guess it's the fact that he's been approved as a core teacher. He has some familiarity with Tennessee law, and the largest part, I think, of the pre-license course probably is aimed at the national, the national information as opposed to the state. But I really don't know the answer, and I told the person I would check and see.
Is he approved to teach the core course by us?
He was approved by you all, by the commission to teach the core course.
Well, there's a good bit of Tennessee law in the core course.
Yeah, I mean, as I say, because it's a pre-licensed course, I just wanted, and he's not licensed in Tennessee, and the rule doesn't specify one way or the other that you have to be licensed in Tennessee.
So, Ms. Maxwell, what you're saying is that it is of your opinion that we have the authority to approve this individual?
I mean, the rule is silent. It says, that you have to have 5 years' experience as a broker, I believe. For continuing, yeah, that's right. And the
But
pre-license says.
Julie, it doesn't address
Statute.
residents.
No, it doesn't. And the statute says that you have to have been.
But that's for continuing.
No, I know the statute.
What's that rule number, Julie?
I'm looking at the statute.
Yeah, the statute, it was a rule, and then it became it was a rule for pre-license, then it became a statute in maybe 2010, when the instructor rules came in, the instructor statute. Let me find it.
I think I'd feel better if he had his own Tennessee license.
What, Julie?
6213-324 is the statute.
Of course, in real estate.
I'd like to make a motion, we deny his request until he gets a Tennessee license.
Is there a second to the motion so we can open this up for discussion?
I'll second it so we can open it up.
All right, the motion is made by Commissioner Collins and seconded by Commissioner DeCharo that we deny this applicant's request until he has a Tennessee broker's license, or?
I don't care. He needs to know the law of Tennessee. I'd hate for a student to listen to his tutelage and end up making a mistake.
Other discussion, we'll wait on this review that's in progress before we vote, but any other comments while we're doing that?
I think that's my biggest concern too, is that he's giving them the right information, but if we've approved him as a core instructor, that does make me feel better that he has that under his belt.
Does the course that he's going to teach, or is there a specific course he's being,
He has,
Proposed to
the
teach?
company that he is sponsored by has a pre-licensed course that is, I say, it's an internet course. It's Arello certified. I mean, it's offered in other states, a number of other states. So it's Arello certified, and Arello requires that all their instructors have an IDEC certification, which is a distance education certification, and he has that as well. So there is a course, there's a course out there that he intends to, that he does teach now. Obviously, the state portion changes as he goes from state to state.
would he meet the requirement of 6213-324A4 that says if the course concerns the principles of real estate, mathematics, or sales techniques, is a licensed broker?
He's licensed as a broker in Kentucky, so that's why I really brought it to the commission, because I didn't really know whether he would or wouldn't meet the requirement. He is licensed as a broker in Kentucky and a couple other states, but just not in Tennessee.
How long has he been an instructor? You know?
Excuse me?
How long has he been an instructor?
I feel like the first course he taught was in around 96, so he's, been an instructor for a long time. I mean, of different courses. I mean, there are a variety of courses at this particular
Call for the question.
sponsor.
Hey, I'd like to withdraw my motion because I did not understand that he was Arello approved. Since he is Arello approved, I don't have any problem with it.
What about you, Mr. Charles? You want to withdraw your second?
I will.
All right, the floor is open for a new motion.
Then I move that it be approved.
I second that motion.
Mr. Alexander moves, and Commissioner Stevenson seconds that this instructor be approved. Is there further discussion? Hearing none, all those in favor of the motion, vote aye.
Aye.
Those opposed, no. It is unanimous. Ms. Maxwell, anything else on the education report?
No, that's all in the education report.
We're
Move to
adjourned
recess till
until
1.
1 o'clock. Please be on time.
Has our major league found us?
11:30.
I'm sorry. Are you ready for us? Thank you. Well, let's get started. All right, the next item on our agenda is an informal applicant appearance by Timothy Ray Lung, applicant, and Cindy Garver, principal broker. Are you those two? Would you mind coming up here to these two seats at the end of this table? And before you sit down, raise your right hand, and our legal department will swear you in.
The whole department.
You are the whole department as far as I'm concerned. Just those two seats. Just
Do you
keep-
mind raising your right hand before you take a seat? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
Ms. Maxwell, if you will start.
Yes. Timothy Ray Lung and his principal broker, Cindy Garvey, are here today as an informal applicant on behalf, Ms. Garvey's here on behalf of Mr. Lung. Ms. Garvey is the principal broker of United Country Leapers Fork Land and Home that's located in Franklin, Tennessee. Ms. Garvey was first licensed as an affiliate broker on 1/24 of 1989 and was first licensed as a broker and a principal broker on 10/11 of 2000. The track records reflect that the firm currently has 4 affiliate brokers, no brokers, and 1 principal broker, Ms. Garvey. Ms. Garvey has had 2 complaints filed against her. One was dismissed by the commission, and the other was an E&O complaint for failure to supervise, which was closed in 2011 with a $1,000 consent order. The applicant, Timothy Ray Lung, has applied for an affiliate broker license. Mr. Lung has passed the exams and revealed the following. On 5/25 of 1984, Mr. Lung was convicted in Greene County Circuit Court in Springfield, Missouri, of fraudulent use of a credit card, which was a felony. Mr. Lung received a suspended sentence of 2 years probation, but states that he was released from probation early in July of 1985. On 6/21 of 1984, Mr. Lung was convicted of DUI, which was a misdemeanor. and he was out with some friends and was pulled over, and he paid a fine for that. As to the felony charge, Mr. Lung stated that he graduated from high school in 1981 and received a football scholarship to Evangel University in Springfield, Missouri. After arriving in Springfield, Mr. Lung says he suffered an injury and could no longer play football, and started hanging out with people who had very little direction and very little motivation to do anything but party. One of Mr. Lung's friends at the time suggested they go visit a gym, and while at the gym, Mr. Lung and his friends got a wallet that was sitting in some pants that were either in a locker or sitting out on a bench. And Mr. Lung took a credit card and went to the mall and went on a shopping spree, as he describes, and was detained and escorted by the mall police before he got out with the items that he had purchased. This incident resulted in the felony which Mr. Lung has reported. Mr. Lung reports that he has been married for 28 years and has 5 children. Since 1990, Mr. Lung has started, owned, and operated several businesses, including a crop insurance business with a proprietary GPS mapping service for farmers and large cattle and crop farms. Currently, Mr. Lung owns and operates Crawdaddy's Classics LLC, a gourmet flavorings company which distributes its product to Kroger, Whole Foods, and online consumers. He also is the owner of a publishing and record label. And I'll let Mr. Lung elaborate further.
So, first of all, do you agree that everything Ms. Maxwell said is correct?
Yes, thank you, Eve. You did a good job of summing it up, although somewhat humiliating to think back to those ignorant days of my life.
Lung, will you move up to the microphone? We have to get this on record.
Okay.
I know you don't like that idea either. I wouldn't.
Do I need to repeat that?
No, that's
okay.
fine.
Regarding Crawdad's Classics, I did bring you on the back there at the table. I've got a little sampling of our products there for you, and it's not intended as a bribe in any way. So, if you elect not to pass me through, I still want you to try our stuff. So,
You've got a fallback position in mind. So, could you elaborate to whatever degree you'd like about what was going on back in those days?
well, primarily in the early '80s, I think it stems back my checkered past or rough and rowdy days in college. Primarily football was my life. It was my dream and my ambition. And after sustaining an injury that kept me from playing, I just lost direction. And I think, one incident that may have kind of tilted that over was after I remember vividly sitting in the doctor's office with my defensive football coordinator, and I was a linebacker, and they had high hopes for me, and he was pretty disappointed I had sustained a neck injury. And the doctor said, Tim, you can quit playing, or you can keep playing with a collar. At the time, it was called a Laporte collar, which would basically immobilize my movements. Or if you get injured again and sustain a life-threatening injury, so you could either quit playing or take a chance on getting paralyzed for life. So, the choice was pretty clear that I couldn't play. Evangel did let me keep the scholarship and help the team, but I helped the team in terms of setting up practice dummies and washing the practice jerseys and things. And I remember a specific incident in the locker room where one of the guys was teasing me about being the laundry boy, and that's all it took to kind of push me over the edge, and that led to a fist fight in the locker room, and I think I pretty much went downhill after that. Had a great upbringing, but just got involved with a crowd that had no direction as well, and so marijuana and bars, and I was a bouncer for a while. It was the only thing I could find to make income at the time, and so I lived that life. That was my lifestyle, and that party scene with the women and booze and that whole thing, and which really led to a cocaine dependency, and that really grabbed a hold of me. I started turning around after this incident. When I got arrested at the mall, that really opened my eyes. As a matter of fact, one of the ladies or one of the gals that I'd been seeing off and on was at the mall when that happened, and
I remember her saying, "Tim, what's going on?" So I'm walking out of the mall handcuffed with my head down, humiliated and embarrassed, and can't believe that I did what I just done. And so when you're in that kind of lifestyle, things don't really matter a whole lot. You're just thinking about the moment. You don't think about the ramifications or repercussions of your actions. And after that is when I really realized that I had to do something with my life. And so I started attending church and met my wife there, and her and I started dating. And but the cocaine dependency was still there, and I was pretty good at hiding that from her until we got married. So I'd kind of go off and on, but I did good after we got married. But then shortly after we got married, or before we got married, then shortly after, I started back on it again because those same guys came back into my life, and so that headed me down that same path and of drug abuse and marijuana. And it was I was working for Keebler Company at the time, and I don't know if I've got that on my resume. I don't think I do. This had been in 1986, because it was a short stint. But I'll never forget pulling into my driveway with my little Keebler Company car, and my wife was moving out, and she was moving out because we couldn't pay rent because I'd spent our money on my lifestyle of cocaine. At that time, I moved back with my parents, and it's kind of a long story. Ultimately, that led to I had to do something. I knew that I couldn't control it. It was controlling me, so I was led to a program called Teen Challenge, and I went to that program in Cape Girardeau, Missouri. It was a 12-month program. Tammy and I were separated, but she told me that if I would complete that program, she would wait for me. And so I completed the program, faith-based program, and I'd say today that I'm living proof of the grace and mercy of God in someone's life, and a loving spouse that saw something in me that even I couldn't see. And shortly after that, I completed the program in '88. Then my wife got pregnant with our first daughter, Chelsea, and that's when my life changed through that. And so I started taking life serious, and got a job with American National Property and Casualty. That started an opportunity for me to open my own claims adjusting business, which then led into crop insurance, the crop insurance industry, and we started that company, Midwest Crop Insurance, in 2000. We were acquired in November of 2010 by a company out of Arlington, Texas. I was the COO of the company. During this time frame, I've always had an ownership interest in real estate, from commercial to residential rentals, cropland acres. I farmed. We had Sycamore Grove Farms in Illinois. It was a small farm, comparatively speaking, but it was a hobby and medicinal for me, and I loved planting beans and corn and raising cows and horses. And after our acquisition, or prior to our acquisition of Midwest Crop, I had bought my family's label. My father-in-law, a.k.a. the Crawdad, he's a retired railroad guy, started a hot sauce in 1995 called Crawdad's Classics. I bought that from him, and as a commitment to him that I'd keep the brand alive for the family as his legacy. When I bought it, I really never intended to create a business out of it. It was more of a, maybe, I guess, a preservative posture to get the intellectual property and just preserve the company. Well, after our acquisition of Midwest Crop in November of 10, I stayed on as a VP of the company of AgriLogic. And then in December of 11, I decided that I wanted to launch Crawdad's Classics in a bigger way, which led us to Nashville. I was living in Camp Point, Illinois, a small rural community. That's where I was raised. My it's interesting. October of 11, Crawdads Classics was invited to attend the inaugural Hot Wing Festival here in Nashville, down on the Country Music Park of Fame downtown here. And in talking with the promoter of that event, we got to discuss my daughter Madison and her talents of singing and songwriting. And so while she was, they invited her to sing, and so we did that event in October of 11. Madison sang. Two ladies that were there that day just loved her music, loved her sound, and those ladies are still dear friends today. And that led to a number of introductions for Madison, which has been an incredible journey for her. It led to some introductions for Crawdads Classics, and we shortly thereafter became the official hot sauce of the Nashville Predators. So if you go to the Bridgestone Arena, you'll see our logos wrapped around the condiment carts there and our gallon jugs of hot sauce, and they put our other products in the suites. And during this, so the next year and a half, we were traveling 8 hours one way from Camp Point, Illinois, little Mayberry town, to Nashville once a month. And my daughter was doing her training and performance coaching and the things that she was doing, and her working on her album. And I was promoting Crawdads Classics, and we started feeling a heart tug for this area. We fell in love with the Leapers Fork area and Williamson County, and we decided in November of 2012 that we would test that tug to see if that was providential. And so we put our home on the market. I made one phone call to a friend of mine who was farming about 3,000 acres, and selling farmland in my area is really not difficult. It took one phone call to make that happen, but I knew if our home sold, it would be a complete miracle, because when I built our home, I built a large home, and it was way overbuilt for that area. I never intended to sell our home, and 6,700 square feet of house and 2 big barns and a shop. And just so happens that when we put the home on the market in November and March, the realtor called and said, "Tim, I got a doctor in Quincy, Illinois," which is in Camp Point. When we said we're going to town, we're going to Quincy, which is about 25 miles west of Camp Point. And so our home sold to the doctor, and we saw that as a sign that this is where we needed to be. So we landed in November of 2013 in Leapers Fork, and that's where we've been ever since. And so,
Does any member of the commission have a question for the
I
applicant?
don't know why he won't get in the real estate business.
I was thinking the same thing. And just, I'm not trying to limit your
I'm not
time,
either.
but as quickly as you can, if you can tell us why you want to be in the real estate business,
Well,
with all your other interests.
I've always enjoyed real estate from an ownership perspective, and seeing the land prices and the sticker shock that I received when I got here to Williamson County, I thought, man, this has got to be a great business. I mean, all jokes aside, I think there's some tremendous opportunity in that industry. I was in the catastrophe claims business for several years, and I've always enjoyed helping people, and I thought it would be a way to be a really fulfilling career to kind of round out my career. Crawdads Classics is not a company that provides for my family in the level that I want it to or that it needs to. So it would be something that I feel would be able to provide additional income into our home to provide the lifestyle that I want to provide for my wife and children.
Other questions for Mr. Lung? Ms. Garvey, you're likely to be his principal broker. Why are you interested in having him? Let's just start with that.
I've known him for over a year now, and
Would you speak up, please?
yeah, I've known Tim for over a year now. He goes to the same church I go to. I feel like he's a good fit for my company. He would have other people that he is in contact with in the music business and in the sauce business that I wouldn't reach out to. I think he's a good and honest man. He's raised 5 kids. I've met 3 of them on a regular basis, and and his wife, Tammy, as well. And and he lives right there in Leapers Fork, and it would just be helpful to me, and I think I could help him as well.
Mr. Alexander?
Get over where you can hear me. Can you hear me now, Mr. Sarah? Ma'am, your office in Franklin, or is it in Leapers Fork?
It's in Leapers Fork. It's just a Franklin mailing address.
I know where Leapers Fork is, yes. High rent district. How long you been in business?
25 years.
25 years?
I started when I was 7.
How long have you owned? Well,
That's when you bought your first condo, wasn't it?
I'm sorry?
I can double you. I've been there longer than that. Twice as long. How long you own your own company?
Well, I started.
No.
Smart.
I'm sorry.
Garvey.
I know all about your pedigree.
17 years. I'm not sure. 17 years with United Country, Leapers Fork. I think she had it written down. It was when I became a broker. I became the broker and bought the United Country franchise.
Still have a United Country franchise?
Yes, sir.
I don't have any more questions.
Other questions?
Chairman, yes.
Commissioner Boyle.
Ms. Garvey, one of the main reasons that you're here is because you'd be responsible for supervising Mr. Long.
Yes, sir.
Can you explain to me a little bit more about the charge we had in 2011 for failure to supervise?
One of the agents just didn't get her E&O payment mailed in time for whatever deadline that was. She thought she had mailed it in time, and it just didn't make it.
Thank you.
Other questions? Chair, thank you, Mr. Collins. Mr. Collins moves that this applicant be approved to proceed on the path to receive a real estate license, seconded by Commissioner DeCharo. Is there further discussion? If not, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. It's unanimous. Congratulations. Good luck to you, both of you. And hopefully we don't see you back here unless you're just dropping some
Sauce.
Thank you.
off.
Make sure you get your goodies out of the box back there.
Thank you.
Having such a hard time. What part of Missouri were you in?
I was in Springfield, Missouri.
Okay.
Yeah.
All right, guys, you're free to go unless you'd like to
Thank
stay
you.
around for another hour or two.
Thanks very much.
We're about to do legal reports. You might find that real interesting.
Thank you very much.
Thank you.
Not quite yet. Well, let's talk, Ms. Kropp, you got 3 or 4 items on here. Let's start with the proposed rulemaking process, single rule, whatever that means.
Well, first of all, can I just, what's in front of all of you, the paper copy of the policy I redrafted over the lunch break. I struck through the first sentence of paragraph 1, which essentially limited the Bill Toon Award to 1 recipient. But I also, in reviewing the policy, looked at paragraph 2, and it appears that there were restrictions upon when the award could be given. So I also struck that language because it appears as if we're going to be awarding it whenever a commissioner's term expires, which is not limited, I don't believe, to a single month, plus whenever it's otherwise awarded. I just struck that language. I wanted to make sure, though, got a copy of the one I redrafted and a copy of the existing policy, striking through what I took out. I just want to make sure that that's okay with the commission and perhaps maybe get a motion to adopt the new one before I ask Chairman Grease to sign the amended, or the new policy, 2014 CPS 001.
Motion to approve.
Second.
Any discussion? If not, let's vote. All in favor, say aye.
Aye.
Those opposed, no. It's unanimous.
And I have a clean copy. I think that one may have lines on it for you to sign after the meeting.
Okay.
So, thank you. The proposed rulemaking process single rule relates to some information that I sent to all of you individually at the end of last week for you to review so that you wouldn't be just struck blind with this when we walked in here today. And I didn't have any individual questions back from anyone, but I'd be happy to address anything right now. This deals with, like I said, a single rule, and it is a proposed change to existing Rule 1260-01-.01, which is entitled Applications for Examinations. Specifically, this potential amendment would only affect subsection 4, which deals with someone not being eligible for licensure until at least 2 years have passed from expiration of parole, incarceration, conviction, whichever is later in time, for any felonies or misdemeanors. The reason that there's going to be a short clause, basically, that you see on your page there, is due to a piece of legislation that came through during the last legislative session, which creates a new statute, 40-29-107. And I believe I sent you all a copy of that in the email I sent, but it's also on the iPads if you want to look at it as well. And basically, what that statute will provide for is a process for someone who has a felony to petition a court for what's called a petition of employability. And the statute appears to go through the process for filing that petition and the court's ability to grant it. And how this affects us and some other commissions are subsection M of that statute states that if someone presents a valid certificate of employability, no board, agency, or commission who issues or restores licenses, and I'm kind of paraphrasing this, shall deny the issuance, restoration, or renewal of an occupational license or certificate based solely on the person's past record of criminal activity, but instead shall consider on a case-by-case basis whether to grant or deny issuance. That's essentially what you all already do for people such as the last gentleman and the person that came in this morning if it's outside that 2-year range. But the way your rule is drafted, if it's within 2 years, if it's any felony or misdemeanor involving theft, they're barred by this rule being in effect regarding the 2 years for any for any felony or misdemeanor involving theft. So subsection M4 of the statute allows that a commission may adopt a rule that still can deny licensure if there's a basis on the time elapsed and the nature of the offense, both of which your rule already does. So essentially, it's just a clause at the beginning of the paragraph saying, notwithstanding a person's possession of a certificate of employability under this statute, if it's less than 2 years from a felony or misdemeanor involving theft, you cannot have licensure. So it's really just something to address this new legislation to kind of make that process simplified going forward. I can answer any questions you have about that so far, but then I can move on after that.
Are you going to ask for action from this commission at some point on this issue?
Yes, what I'm asking for is, and I spoke with, because we already have this rulemaking process that's going along, adding this rule would hold up your rules because you've already done the preliminary regulatory flexibility analysis. It's already been reviewed through the department, and this would be adding a new rule. There is, however, in the statute a process for what is called a proposed rule, and it's a little bit different process than what we've done for our other rulemaking processes because many of the rules you all adopt, specifically this advertising one, are going to lend themselves to many public comments, and I think you all welcome those comments. The proposed rulemaking process is a little bit more streamlined in that we do all of the analysis up front today, adopt the proposed rule by roll call. It's still reviewed within the department and by the AG and governor's office, but it is then filed with the Secretary of State's office for a period of time. There would not be a rulemaking hearing unless we receive a petition from 25 or more affected persons or a municipality. It's specified in the statute. Basically, we would not have a rulemaking hearing on this one rule. Not any of the other rules. It would only affect this one rule. We would not have a rulemaking hearing on it unless we were specifically requested. And the reason why we would just be going this route for this particular rule is it is merely to kind of address this one narrow issue. I wouldn't expect that we would have many comments, and we don't want it to affect our other rulemaking process. So
If this is a statutory requirement or it's a piece of legislation, why do we need a rule to go with it?
Because if you want to utilize this rule that you have here for someone that could come in with this certificate of employability, the legislation requires that the rule must address the fact that someone could have that certificate. I don't expect it's something that will come up very often, and it won't matter if it's been past the 2 years because you all consider those on a case-by-case basis anyway. But this legislation preempts any rule to the contrary, so we can't operate on our existing rule the way it's worded if someone were to come in with that certificate of employability.
Tell me again what a certificate of employability is.
In essence, the only thing I know about it is what's in this piece of legislation, but essentially, as I understand it, it's someone that has had a felony in the past that they can petition a court for a certificate of employability, and the court can choose to issue that if they find that the person has good character, if it will assist them in gaining employment. It's basically, it appears to be a court's recognition of, hey, you should consider this person for employability based on, these factors, despite the fact that there was a felony in the past.
Ms. Crop, just out of curiosity, how long would that process take to get a certificate of employability through a court?
I'm not sure, and I'm not familiar with this process prior to this. This is not even actually effective for purposes other than rulemaking until January 1st of 2015. So this is not something that is yet going on in courts of this state, but after January 1st, it would be a possible process. And I don't see a particular timeline laid out. It might depend on how congested a court's docket is. But this is just an attempt getting this ball rolling early to hopefully streamline this in case we have someone that comes along with one of these certificates.
Oh, just again to help me understand this, Mr. Lung, who came today, if we don't adopt this proposed rule or suggest this, make this a rule, would he still have the ability to come here and plead his case?
Well, Mr. Lung would be different because he didn't have one of these. This change would only affect someone that came in with that certificate. Mr. Lung's issue was well outside the time period barring. Nobody that appears here falls under this rule because they're just automatically, they cannot get licensure. This wouldn't affect someone like him for a couple of reasons. This would affect someone that maybe had a felony, I guess within 2 years and had this certificate. So it's going to be a pretty narrow range, but as I understand it, and this is just, it basically says if we want this rule to apply to anyone, certificate or no certificate, we have to have this clause in there. I guess the alternative, and I could check on this, is if we don't add this, then those people, even if it had been within 2 years, they would be coming in to you all. But in a way that, might not be the most fair thing for someone who doesn't have that certificate but could have the same conviction within the same period of time, so.
Mr. McMullen.
So prior to the adoption of TCA 40-29-107, our rules would have prevented someone from obtaining a license if they had the certain type of conviction within the prior 2 years. Is that right?
The rule as it stands now is exactly just everything that's on here without the underlying information.
But if we do not adopt this amendment, then the new statute 40-29-107 might permit a person who has a certificate of employability from being able to get a license if they've had that conviction within the 2-year time frame?
Well, the statute preempts our rules, so the statute requires review of those people. We would not be able to apply this rule to those people that had that certificate.
So basically, in order to maintain the status quo as it existed before the adoption of 40-29-107, we need to adopt this amendment to our rule.
Right, so that it would affect anybody's certificate or no certificate.
So what do we need to do today in order to move this process forward?
Well, what we need to do is, and I gave you all an attachment, and I have a paper copy so you wouldn't have to flip back and forth. We would have to go through all of the analysis for this rule, which involves the regulatory flexibility analysis, which are those 7 considerations we usually do on the front end of a rule. A few other considerations that are sent up to the governor's office, the economic impact statement, which is 6 considerations, and 1 question regarding the projected financial impact on local governments. Now, to get everyone started, I did do a memo with a drafted response for each one, and I did email that with the materials to everybody individually. I have paper copies I can give you. They're on the iPad, so you wouldn't have to switch back and forth from the rule filing to that. Here you go. But we would essentially have to run through that today and then adopt the proposed rule by a roll call vote, and then I would send it for review prior to filing with the Secretary of State.
Is it the will of the commission to take this item up and get this thing started?
Sure.
Any objection? Without objection, then Ms. Crop, let's do that. We're going to start
Okay.
with the regulatory flexibility analysis.
Yes, sir. It'll be the first, we'll go just through in order that I have them on the memo. I have the considerations that we have to do in bold, and I'll read through them. And like I said, I drafted a proposed statement under each one as a jumping off point, but if anybody wanted to add anything to it, I just usually do that to get the conversation started. So,
In an ideal world, one member of this commission will see the highlighted areas and make a motion to adopt that statement.
if you all agree that those are just great the way they
I said
are,
an
and you
ideal
have
one.
absolutely nothing to add. I did spend some time doing this in hopes that it would at least leave you all, because I know you have a lot of things to consider today, but if you want to use these, if you agree with them, that's fine. Or sometimes you all choose to add things, so.
Especially Commissioner McMullen, is that what you meant to say?
I sent them to everybody ahead of time because I figured he might want to look at them, but, do you want me to just start with the first page, Mr.
Let's do
Chairman?
it.
Okay. The first consideration in the regulatory flexibility analysis from 45402B is the extent to which the rule may overlap, duplicate, or conflict with other federal, state, and local governmental rules.
Commissioner McMullen,
I move that we adopt the statement that there is no overlap, duplication, or conflict with other federal, state, or local governmental rules.
seconded by Commissioner Collins, motion by Commissioner McMullen. Any discussion? Hearing none, all in favor of the motion, vote aye.
Aye.
Those opposed, no. Ms. Crop.
The clarity, conciseness, and lack of ambiguity in the rule.
Mr. Chairman, I move that we adopt the statement that the rule is clear, concise, and unambiguous and seeks to address the provisions of Tennessee Code Annotated Section 40-29-107 relating to an applicant for licensure with the Commission who holds a certificate of employability.
Seconded by Commissioner Collins. Discussion. Hearing none, all in favor, vote aye. Aye. Those opposed, no. It's unanimous. Ms. Crop.
The establishment of flexible compliance and reporting requirements for small business.
Mr. Chairman, I move that we adopt the statement that this rule does not establish compliance or reporting requirements for small businesses, but instead only addresses situations involving a person's application for licensure where that person holds a certificate of employability.
Motion by Commissioner McMullen, seconded by Commissioner Collins to adopt. Any discussion? All in favor, vote aye. Aye. Those opposed, no. It's unanimous. Ms. Crop.
The establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses.
Mr. Chairman, I move that we adopt the statement that this rule does not create any compliance or reporting requirements for small businesses.
Second.
I have a motion by Commissioner McMullen, seconded by Commissioner DeCharo to accept. Discussion. Hearing none, all in favor of the motion, vote aye. Aye. Those opposed, no. It's unanimous. Ms. Crop.
The consolidation or simplification of compliance or reporting requirements for small businesses.
Mr. Chairman, I move that we adopt the statement that this rule does not create any compliance or reporting requirements for small businesses.
Motion by Commissioner Mullen to accept, seconded by Commissioner Collins. Is there a motion to accept, or what, is that what we're doing here? We're accepting that
We
statement?
just made a statement.
And we're
Yeah.
moving that we accept that statement. All right, so motion and a second. Discussion, hearing none, all in favor of the motion, vote aye. Aye. Those opposed, no. Unanimous.
The establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule.
Mr. Chairman, I move that we adopt the statement that there are no performance, design, or operational standards established by this rule.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeCharo to accept. All in favor of the motion, vote aye. Aye. Those opposed, no. Motion carries unanimously.
The unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs.
Mr. Chairman, I move that we adopt the statement that this rule does not result in the unnecessary creation of entry barriers or other effects that will stifle entrepreneurial activity, curb innovation, or increase costs.
Second.
We have a motion by Commissioner McMullen, seconded by Commissioner DeCharo to accept the statement. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. It's unanimous.
Okay, so several other considerations from the governor's office, the first of which is, does the rule make it better to do business in Tennessee?
Mr. Chairman, I move that we adopt the statement that this rule is expected to make it better to do business in Tennessee by helping to ensure that anyone licensed with the Commission is fit and able to perform the duties and responsibilities necessarily related to real estate licensure.
Motion by Commissioner Collins by Commissioner Mullen to accept, seconded by Commissioner Collins. Discussion. Let's vote. All in favor of the motion, vote aye. Aye. Those opposed, no. It's unanimous.
Does the rule make it easier to create jobs in Tennessee?
Mr. Chairman, I move that we adopt the statement that this rule is unlikely to have a foreseeable impact on job creation in Tennessee.
Second.
Motion by Commissioner McMullen, seconded by Janet, also AKA Commissioner DeChara. Is there discussion on the motion? Hearing none, all in favor, vote aye. Aye. Those opposed, no. It's unanimous.
Is it essential and effective?
Mr. Chairman, I move that we adopt the statement that the rule is essential and effective in addressing the provisions of Tennessee Code Annotated Section 40-29-107 relating to a person who wishes to obtain licensure with the Commission and who presents a certificate of employability to the Commission.
We have a motion by Commissioner McMullen, seconded by Commissioner Collins to accept or to acknowledge the statement. Discussion? Hearing none, all in favor vote aye. Aye. Those opposed, no. It's unanimous.
Who does it affect?
Mr. Chairman, I move that we adopt the statement that the rule affects any person who wishes to obtain licensure with the Commission who possesses a certificate of employability, but who also has a felony or theft misdemeanor conviction where less than 2 years have passed from the date of expiration of probation, parole, or conviction, or from the date of release from incarceration.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara to accept the statement as read by Commissioner McMullen. Discussion? All in favor of the motion, vote aye. Aye. Those opposed, no. It is unanimous.
Is the rule a positive move?
Mr. Chairman, I move that we adopt the statement that this is a positive move because the Commission's adoption of this rule denying licensure for a specified period of time for certain offenses, despite a person's possession of a certificate of employability, results from the fact that the time elapsed and nature of the offense have a direct bearing on the fitness or ability of the person to perform the duties of a real estate licensee, and this rule will serve to protect the safety and welfare of the citizens of the state of Tennessee.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara to accept the statement as read into the record by Commissioner McMullen. Discussion? All in favor of the motion, vote aye. Aye. Those opposed, no. It is unanimous.
Is it outcome-based, or does it have a measurable positive outcome?
Mr. Chairman, I move that we adopt the statement that this rule will serve to protect the safety and welfare of the citizens of the state of Tennessee.
Is there a second?
Second.
Seconded by Commissioner DeChara. Those in favor of the motion to accept the statement as read by Commissioner McMullen, please vote aye. Aye. Those opposed, no. Unanimous vote.
Now the economic impact statement pursuant to Section 4-5-401, or I'm sorry, I guess 4-5-403. The type or types of small businesses and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule.
Mr. Chairman, I move that we adopt the statement that this rule is not expected to have a measurable impact on small businesses.
Motion by Commissioner McMullen, seconded by Commissioner Collins. Discussion? If you agree with the statement, please vote aye. Aye. Those opposed, no. It's unanimous.
The projected reporting, record-keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for the preparation of the report or record.
Mr. Chairman, I move that we adopt the statement that there are no projected reporting, record-keeping, or other administrative costs required for this proposed rule.
Second.
We have a motion by Commissioner McMullen, seconded by Commissioner DeChara to accept the statement as read by Commissioner McMullen. If you're in agreement, please vote aye. Aye. If you're opposed, vote no. It's unanimous aye.
A statement of the probable effect on impacted small businesses and consumers.
Mr. Chairman, I move that we adopt the statement that there is no expected adverse impact on small businesses as a result of this proposed rule. This proposed rule is expected to assist with the protection of the welfare and safety of the citizens of the state of Tennessee by helping to ensure that all licensees are fit and able to perform the duties and responsibilities necessarily related to real estate licensure.
Second.
Second. A motion by Commissioner McMullen, seconded by Commissioner Charo. Members of the commission, if you agree with the statement as read, please vote aye. Aye. Those opposed, no. It's unanimous.
A description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small business.
Mr. Chairman, I move that we adopt the statement that there are no less burdensome, less intrusive, or less costly alternative methods known which will achieve the purpose and objectives of this proposed rule.
Second.
We have a motion by Commissioner McMullen, seconded by Commissioner DeChara. If you agree with the statement as read into the record, please vote aye. Aye. Those opposed, no. Ayes have it.
A comparison of the proposed rule with any federal or state counterparts.
Mr. Chairman, I move that we adopt the statement that there are no known federal or state counterparts to this rule.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara to accept the statement as read into the record. Discussion, hearing none. All in favor, vote aye. Aye. Those opposed, no. It's unanimous.
Analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule.
Mr. Chairman, I move that we adopt the statement that any possible exemption of small businesses from this rule would result in less protection for the citizens of the state of Tennessee.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara. If you agree with the motion, please vote aye. Aye. Those opposed, no. It's unanimous.
Finally, pursuant to Tennessee Code Annotated Section 4-5-228, we just need a simple declarative statement adopted regarding whether the rules may have a projected financial impact on local governments.
Mr. Chairman, I move that we adopt the statement that the proposed rule is not projected to have any financial impact on local governments.
Motion by Commissioner McMullen, seconded by Commissioner Collins. You heard the statement. If you agree, vote aye. Aye. Those opposed, no. Motion carries unanimously.
The last thing that we have to do on this matter is just vote by roll call whether or not to adopt the proposed rule, which would amend paragraph 4 of Rule 1260-01-.01 by adding the phrase, notwithstanding a person's possession of a certificate of employability pursuant to Tennessee Code Annotated Section 40-29-107.
All on the commission understand what we're about to vote on? If so, Ms. Maxwell, if you'll call the roll.
Stevenson?
Yes.
DeChara?
Yes.
Grease?
Yes.
Collins?
Yes.
Bloom?
Yes.
McMullen?
Yes.
Alexander?
Yes.
Franks and Flitcroft are absent, so it's 7-0, and 2 people are absent.
Are we done with this item at this point?
We're done with this item. What I'll do now is route it through the department. It'll go up to the Deputy Commissioner and General Counsel. Then it'll go to the AG's office, then the Secretary of State. It will be posted to the then the Governor's office, then filed with the Secretary of State. There will be notifications that this is sent out, but like I said, there will not be a rulemaking hearing on this unless we receive a petition from the requisite number of people or groups in order to do that. And all of that will be described on this rulemaking form. It is a special rulemaking form. So I will keep you updated on it, but that's all I need from you today on this.
Great, thank you. Discussion concerning reinstatement rule provision.
Okay. This is switching gears to our other rulemaking project, totally separate from the one we just did. The one that we had discussed earlier, their advertising clump. And I did pre-email you, all of you, about this as well. We had sent these proposed rules to the Attorney General's office for review of constitutionality, and I received comments back about a week ago, I guess. And all of the changes were just grammatical, simple word changes, nothing affecting substance at all, except for one that you will find on page 4 of the of document number 16 on your iPads, draft 5, notice of rulemaking hearing red line. It's going to be found on page 4 of that. Specifically, the subsection we're dealing with is found within the proposed Rule 1260-01-.21 regarding reinstatement. Specifically, it would be subsection 2B2II. It's about maybe 80% down. It's right above paragraph number 3, which says other condition. It begins with for a license expired more than 120 days. Does everybody see where I'm at? The AG's office position is that paragraph for that time period, the penalty fee cannot be more than $100 per month per statute. And because that's an issue that's somewhat substantive in nature, I'm bringing it back to you all to let you know that this was the comment we received, to let you all determine if you want to make any changes with that or not.
So do we just need to change 150 to 100?
Their position is it can't be more than 100, yes, for that
Okay.
paragraph.
You just need a motion to do that?
Yes, and we don't have to, I would just then be able to go back to them and let them know that you all voted to do that at this meeting.
I move that we change section 1260-01-.21 to B to II, where it says $150 to $100.
You've heard the motion, seconded by Commissioner Collins. Now discussion. So since we have no discussion, let's vote. All in favor of the motion, vote aye. Aye. Those opposed, no. It carries. Do you want to give us just a little preview or your sense of how this is progressing at this point?
At this point, when I take this back to the Attorney General, I will, of course, also incorporate the changes to the advertising rule that you all discussed and adopted by motion this morning. I will point those out to the Assistant AG when I send them back, because I'd informed her that I was only going to be coming back with this one issue, so I don't want to try to slip something past. But assuming she has no questions, I would assume that approval from them would not be held up at all by anything that you did today, and we should receive that approval shortly. At that point, the next step is to send it to the Deputy Counsel at the Governor's Office, and for the Governor's Office to make a review of it. I don't know how long that'll take. It took longer than it had in the past for the auctioneer rules that I just got back, but those went a little earlier toward the end of session, and I think that could have been some of the reason for delay. As soon as I get the approval back from the Governor's Office, I can file it for noticing a rulemaking hearing with the Secretary of State's website. At that point, these rules will be open to the public. At this point, they're still drafts. We can't give copies to anybody or anything of that nature. But once they're noticed for the public for the rulemaking hearing, they'll be posted to the Secretary of State's website. There'll be a link on the department website. There'll be a link on our website. It will be sent out on the Notify application by email to everybody who signed up for that. And at that point, we will have the period of time before we can have the rulemaking hearing. And right now, I believe it's around 50 days. It has to be on file with the Secretary of State's office before we can have the rulemaking hearing. So as soon as I receive that approval, I will calendar it for as quickly as I can for a normal business meeting, probably beginning at 9:15 or 9:30 on the first day of one of our meetings, as soon as I can, and get that statutory notice in there to allow for comments before the hearing. So that's kind of where it goes from there, and I can go further than that, but I guess we just, up to the rulemaking hearing is the main, probably.
Do you want to give us a consent order log first, and we'll take a quick break and then finish
Sure.
up with your stuff?
It's on your iPads, second one from the bottom. Item number 20, and I just present this as part of my report every month. It's my kind of tracking mechanism for things that have been sent out. You'll see that some of the ones down closer to the bottom have either not responded or requested a formal hearing. They've been moved over. We had quite a few last month. We've only had one person so far satisfy the consent order, but those were sent out just shortly before the middle of the month, so they've still got a little more time. But this, like I said, I just provide to you all every month so you have an idea of how these are moving along and that they have been sent out, the ones you've authorized. So
So like the very last one, for instance. This was back in September of last year.
yes, and I might have, I've got the names pulled off of those, so I want to look at mine. Yes, that one I believe is currently calendared for a formal hearing in the next couple months.
Is there an objection to taking a 10-minute break and then coming back and knocking out the legal report? All right, we'll be back in 10 minutes.
Oh, and
Sorry, we're still in session.
I do have just the legislative proposal update, but I can do that right after the break as well.
That'd be perfect.
Okay.
Hey, Janice, what I'm thinking, we're back in session. Commissioner Stevenson has asked for the floor. Commissioner Stevenson.
Commissioners, I just want to say and call your attention, Kimberly Smith, who has provided all of our refreshments and been in charge of that, and those little skewers with the baby marshmallow and the grape, she did all of that. And I just want to say thank you, Kimberly, for doing that for us.
Absolutely. Thank you. All right, with that said, and it was properly said, thank you, Commissioner. I've asked Commissioner DeChara to give you a little orientation, first about this commission, and then second of all about what we're about to go into. So, Commissioner DeChara.
Well, Commissioner Flitcroft always says the next part of our session's more fun than Oprah Winfrey, but I'm not so sure that it's more fun than that. But our commission is based out of, we have 9 members, as most of you should know, 3 from each section of Tennessee. We have 2 public members and 7 industry members. Commissioner McMullen is our only public member who is here today, and he's an attorney who practices law here in Nashville. So if you need a good lawyer, call Austin, because you can see he's pretty sharp, and he's the brains behind this bunch. Next to him, we have Grover Collins. Grover is also from Middle Tennessee. Commissioner Grease is from East Tennessee. Commissioner Stevenson, who's just here today and gone tomorrow kind of thing, is from East Tennessee, and we don't know who his replacement will be. Commissioner Bloom is from West Tennessee, and Commissioner Alexander's from West Tennessee, and I am from West Tennessee. Our other public member is from East Tennessee, and that's Commissioner Flitcroft, and then Commissioner Franks is from Middle Tennessee. So we have quite a variety here. What we're about to do is the complaint log, and our attorney, Miss Julie Kropp, goes through these complaints every month and puts together this report that we're about to hear. When we hear these complaints, we hear exactly the same thing you do. She doesn't send us the names of people beforehand. We don't have a clue who she's talking about. All we're doing is listening to the case itself. So you know as much about it as we do. And as you keep that in mind when Julie's reading through this, also keep in mind she's the attorney for the Auctioneer Commission, and sometimes my ears don't listen as fast as she can talk, but she does a great job, and we appreciate Julie. And then if it goes far enough, Miss Robin Ryan is our litigator, and she doesn't like to lose, so you don't want to be on the opposing side of the table from Miss Ryan.
And let me add one thing. On each of the cases you'll hear today, Ms. Kropp will make a recommendation to us. And we can either agree with the recommendation, disagree with it, modify it, but at that point, whenever we're done with the vote on that particular case, it'll go back to Ms. Kropp, who will, in essence, go to the person, the complainant, and the respondent, and give them the decision. And if there's a decision that involves any type of civil penalty, they'll have the right to accept or reject whatever the recommendation is, whatever Ms. Kropp takes to them. If they choose not to accept it, they have every right to a formal hearing, and that's where Ms. Ryan comes in. And from your perspective, we don't have a formal hearing tomorrow, so that's why we only have a one-day session. Typically, we have our formal hearings on the second day of the session, and they're with the judge. We're the jury. It's pretty interesting. So we're going to Ms. Kropp's going to read the case, make a recommendation. We'll decide what to do with that recommendation. When we're done on that particular case, Her charge will be to go to the respondent and complain and report and see what's next. We're ready. Thank you,
Okay.
Julie. Thank you, Janet.
Do you all want to go ahead and cover the legislative proposal topic briefly before this? I don't expect it'll take very long.
Let's do
but-
that.
Okay. We were asked to compile a list of legislative proposals that you all want to submit, for the department to submit for legislative session in 2015. The deadline was on Monday, but since your meeting was just a couple days after, I thought I would run it past you all. There were a couple of just housekeeping issues in some of the statutes where one subsection didn't exactly agree with the other that Eve and I discussed. But as far as of things that you all might want us to request the department carry in its legislative package for next session, I referred back to your list that you gave me last year. And as a reminder, the requests you had at that time, and I can let them know if you no longer wish to keep any of these on there, or if you'd like to add some, take these off, is first to include the preparation of broker price opinions within the definition of broker in 6213-102. Is it 102? I'm drawing a blank. And you all had asked for that last year.
You want to do this one at a time?
Well, I was going to give you all three of them and then let
Okay.
you know, or you can take them one at a time. Would you like to keep that one in
You've
there?
got the microphone. You just keep on going.
Okay, the second one that was requested last year was that to ask that 6213-318, which is referencing license retirement. It currently requires the completion of all education requirements in order to retire a license and requires no education to reactivate. Your request last year was to have a revision to that code section to instead allow for retirement of a license without completion of all education requirements, and in the alternative, require any licensee wishing to reactivate his or her license to have all education requirements for that licensing period in order to become an active licensee once again, essentially making the education requirements effective when you want to reactivate. The third request that you all had last year was to revise 6213-110, which is regarding unlicensed activity, to authorize the commission to assess a higher penalty for unlicensed activity. I believe it was tossed around maybe $5,000. I think Commissioner Flitcroft liked that number because it was maybe in an Oklahoma statute somewhere. Those are the three things that we included as requests from the commission in last year's legislative package. They did not get picked up, but I included them again this year because I didn't have anything else to go by for when I submitted these on Monday. If you all would like to let me know if you still like these, if you want more, want less, just let me know and I can forward that information along. No guarantees as to what will happen with it, but I will at least, present it.
Any comments?
I'd like a motion, we send them on.
They've been sent, but
I guess you're saying you like those three,
Yeah.
right? Okay.
Yeah. Okay, without discussion, without objection, Julie, I'd say keep them like they are.
Okay. All right. I won't make any changes. I just wanted to be sure.
Thank you for checking with us.
Thank you. All I have left is the legal report now. I'll begin by reading the statement on the first page. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. The first matter is 201, I'm sorry,
We'll have a copy, it's all on.
it's not on there?
Yeah, I've got, but we don't, usually we have a printed copy, no printed copy this month.
I'm sorry, I gave it to him for the iPads. I can get you one.
Nope, I just been spoiled.
I'm sorry. Yeah.
You
If
know
want me
better
run
than to
upstairs,
spoil him.
I can ask my paralegal to
No.
print you one.
Oh,
Okay.
I'll do it.
All right.
I'll back out.
The first matter is 2014-001131. Complainant alleges that respondent, unlicensed individual, acting for a corporation, purchased 2 properties in Tennessee and sold them to complainant's company on the same day in 2012 for a higher price, without making any improvements to the properties. Complainant states that respondent had an understanding with a third party to repair these properties to a rent-ready standard. Complainant states these properties remain in a condition which would not allow them to be rented. Included in documentation provided by complainant were warranty deeds conveying the property to respondent's corporation and warranty deeds signed by respondent conveying the property to complainant's company on the same day. Also included with the complaint were copies of respondent's corporation's website advertising itself as buying and selling property. Also included were settlement statements for both properties when they were conveyed to complainant's company from respondent's corporation. Respondent submitted a response through an attorney stating that respondent's company was the owner and seller of the subject properties. The attorney states that respondent individually did not own or sell the properties, and respondent's company are not licensed to sell property. Further, the attorney states that there was no violation because respondent's company is exempt from the licensure requirement since it is the seller of property it owned and it did not earn a commission on the transaction. In response to requests for additional information, respondent's attorney stated that respondent is president of the corporation and is primary shareholder acting on the corporation's behalf. Further, respondent's attorney states that respondent runs the corporation and is not salaried. It would appear from the documents provided that respondent does not qualify for the license exemption found at Tennessee Code Annotated Section 6213-104A1F because it appears that respondent is performing activities described in Section 6213-102 as a vocation. Therefore, the recommendation is a consent order for $1,000 for unlicensed activity in violation of Tennessee Code Annotated Sections 6213-103 and 6213-301. Said order would also include an order to cease and desist all unlicensed activity.
Motion to accept council's recommendation.
Second. Discussion. I'm personally struggling with this. A corporation bought the lots, or bought the 2 properties, and flipped them the same day.
Correct, for a profit to another company, the complainant's company.
Profit go to the corporation?
Presumably, I do have copies of the HUD statements. There was no commission showing up on the HUD, but presumably the corporation would have taken that profit. It was a significant profit on each one of the subsequent sales.
They took title to the property and turned around and sold it.
The corporation was the
Corporation
seller,
owned
not
it.
this individual.
Right, the corporation owned it, and the corporation sold it. I'm sort of like John.
The penalty is not to the or the civil penalty you recommend is not to the corporation.
No,
It's
sir.
to an individual.
It's to the individual because our exemption that we had the Attorney General opinion on back in March, I believe it was, of this year, is 6213-104A1F. And what that states is, I can read you the exemption. Would you like for me to?
Tell us what it says.
It basically says that the provisions, the chapter doesn't apply to a corporation acting through an officer authorized to engage in a real estate transaction where it occurs as an incident to management, lease, sale, or other disposition of real estate owned by the corporation. But the exemption goes on to say that the exemption does not apply to a person who performs an act described in 6213-102-4A, which is the definition of broker, either as a vocation or for compensation if the amount of the compensation is dependent upon or directly related to the value of real estate with respect to which the act is performed. So essentially, while there is a licensing exemption for someone who is the owner of a property who turns around and sells it, this provision applies specifically to a corporation when there is a person or an officer acting on behalf of that corporation performing those acts. And it states that the exemption does not apply to that individual if the person is doing those acts either as a vocation or for compensation that's related to the profit derived by the corporation. And do you all remember when we sent you the AG opinion? Because you all had requested one on it, and the AG basically very narrowly interpreted that exemption. They even said it didn't apply to LLCs because that's not a corporation. This is not an LLC. But in this case, it appears that this is the business of this corporation. It appears there was no, I checked into it, there was no licensee representing this corporation. This person was the signatory on all the documents for that corporation. This person's role is to run this company as president. It appears that somebody had to have been negotiating this price, arranging for all of this on behalf of this corporation, and there appears to have been no licensee involved on that.
I thought we had a deal here a while back where a gentleman was representing a car dealership, and he had bought several places in Tennessee, and we decided that because he was hired by that corporation to do that, he was allowed to do it. He only worked for that company. Did y'all remember that?
I don't remember anything with a car dealership.
If he's hired by that company to just work for them, I don't see why he'd have to have a license.
I don't remember that set of circumstances. All I'm operating off of for this is the facts of this set of circumstances, this exemption, and the limited guidance that we've been given by the Attorney General's office. I don't remember that.
Well, he
I'm
worked for the
sorry.
corporation.
Buying them, but he wasn't flipping them. He didn't buy it. They bought it and they kept them. This is, I assume where she's coming from is where they bought them and resold them.
Well, it's anybody that's performing any acts under 104, if they're doing it as their vocation or if they're being paid something that stems from the profit derived from the corporation, from basically management, lease, sale, or other disposition. So it's.
Do we have any evidence that this respondent did this other than on the transaction in question where the company bought the two properties and sold them that day or the next day?
This is just this. I mean, this is the only complaint that we've had that's come forward. It was two purchases and two sales that came about the same day. There were website printouts that we were given that advertised multiple other homes. That the attorney advised me that that's not a website they're using anymore, but it is still up on the internet, and it appears to be the thrust of this company to advertise properties either for sale or lease to own. So I'm sure there are others out there, but as far as what we've been given, this complainant was only referencing these two transactions which occurred involving this complainant on that same day. So from the website, I think, there's a strong implication that there's other transactions of this type that have happened because it appears to be an advertised service on the website of this, or an advertised function of this company on their website. But as far as having documents for other ones, these are the only two I have.
So when the company has been advertising, you're saying they're advertising properties for sale on the internet. Is that what you
Yes.
said?
I believe it was sale and lease purchase were most of them.
And were those properties that were currently owned by the company or were they owned by other people?
I don't know that because the website, the printouts were submitted with the complaint back several months ago, so I'm not sure if there have been changes in ownership since then. Again, the attorney said that was an older website, but when I looked at the website, it's still up and running with the listings on there. It's something I can look into if you want me to. I think it's an older.
Why are you looking? I have a question for the commission. If I'm an employee of Holiday Inn or any chain, and I'm going through the country, they come to Tennessee or Weakley County, and they buy that, and they're not licensed, but they're employees of that corporation, and are they out? Is that wrong?
Banks do it every day.
That's what I'm saying. Chains, grocery store chains. What's the impression of the commission?
Individual bought that property, they could still turn around and flip it without having a license.
Well, it sounds like the
McMullen?
Attorney General's ruling just kind of goes against that, what I think is a logical assumption, but
The exemption would only, if the person's not doing it as a vocation, then they could potentially be covered by it. Doing it one time only is not making it someone's vocation. This is, That's what more of what the Attorney General got into in one prong of the analysis, because it doesn't apply if either the person is performing the real estate activities as a vocation, meaning they got into that basically stating it was their regular job duties to do that, or if they're compensated on some kind of commission type basis or some kind of in some manner where it's derived to based on the profit. If it was somebody that did this every once in a blue moon and they were salaried, this exemption would likely cover that person. But if it's somebody that's doing this regularly and either is getting a commission from doing it or is some kind of officer where they're getting a percentage of the distribution of profits that this corporation's gotten through doing it, then that's somebody that does not fall under the exemption according to the opinion. So you might have some people that are doing this here and there that would still fall within the exemption as the Attorney General analyzed it in the opinion.
One of the, I guess, thrusts of my question was, did it appear to you that this is a person who's using their company as a way to facilitate sales of property from between two unrelated people, but rather than having a direct sale from buyer to seller, somehow their company is coming in and buying it and then turning around the next day or the same day and selling it to the other party, and so that was some way they were trying to get around the licensing requirement by doing that?
I'm not sure that these two properties were sold at a pretty significant profit later in the same day. The complainant did allege, and this is not really an issue for us because this person is not licensed. I believe there's a civil suit going on between the parties with regard to the allegation that there was some kind of understanding that this respondent's company was supposed to make some sort of improvements to the property, and those, as promised, were never done. It was sold to this complainant's company with the promise that there were going to be improvements, repairs made that weren't done. So I'm not sure if it was just simply a flip, like Commissioner Alexander was saying. These properties were maybe bought in poor repair and then turned around and sold with a promise they would be upgraded. And so I'm not sure what the intent
Were
was.
these promises made to the buyer?
The complainant alleges that they were told, try to get the wording exactly right, because my legal report's a summary of what they said.
I'm of the opinion it doesn't make any difference. It's either legal or illegal. It's whether you make $100,000 or whether you make $100. It's
The complainant says his undertaking an obligation with a third party, and it's got the name there, was to repair these said properties to a rent-ready standard, which he has failed to do. That's what the complaint is. Again, what that part of the breach of whatever.
But was the people that were the buyers the one that made the complaint, filed a complaint?
The purchasers, the people that bought the two properties at the higher price from this respondent's company are the complainants here.
Why shouldn't we wait till the civil suit's over before we decide on this?
Because the issue that we're only determining is whether unlicensed activity took place. This is essentially, I mean, I guess what it would probably boil down to is a breach of contract type of dispute in court of you promised you would do these things and you didn't, and that's really not any part of whether, as Commissioner Alexander I think was saying, whether our law has been violated here, whether this person broke promises to the other person is really not the issue we're taking up. Is just merely, did this person need to have a license to do what?
So our decision would help decide the case, maybe.
I'm not really sure, because I mean, I think still if they said that they would do things and didn't, even if you all said they didn't have to have a license, there could be some problems civilly in litigation in a court of law. It's kind of two separate issues. I'm not really sure how it would affect it, but I'm not sure that whatever the court decided would affect our determination one way or another. It's not like some of the cases we see where the underlying litigation is over the same allegations. It's really not the same thing here.
Could you clarify the sentence that says respondent's attorney states that respondent runs the corporation and is not salaried?
I had asked for additional information, and specifically, I believe my question was, what were the duties as president of the corporation, and did the person get paid through a distribution of profits, or is the person salaried? And the response I got from the attorney is blank, the person's name, runs the name of the company, he is not salaried, is the only response I got to that.
So here's what I think. It appears to me the Attorney General at some point has tried to stop unlicensed activity or end runs by a person incorporating themselves to get, as a stockholder, dividends or proceeds that would logically or normally be considered commission. It appears to me in this case, this guy went out, found a piece of property, went out, found a buyer, acquired a piece of property, sold it to the buyer. All of that sounds like it could be considered licensed activity requirements. I can make the other argument that it also could be an entrepreneur is out buying property and flipping it. Do you think, Julie, the complainant knew he was closing on the property the same day he sold it to them?
I'm not sure because, like I said, this was kind of filed much later on. The complainant is aware of it now. I'm not sure if that came to light later on or how that evolved because I only have the benefit of knowing about it after the fact. I'm just not sure. I mean, I've got the documents where they are correct, it did occur the same day, but as far as that awareness when it occurred, I'm not sure.
Do you think your recommendation is flavored by that recent Attorney General opinion?
Well, the reason you all had requested that opinion is because the exemption, most of the exemptions are a line or two, and this exemption 6 or 7 lines, and it gets rather complicated. But, you know, it in this case, it appears that, you know, the Attorney General did get into more depth in the exemption and, you know, attempted to explain. I mean, of course, the Attorney General didn't draft or adopt this legislation. That would have been the legislature. So it's, you know, something that appears to have been indicated by the intent of the exemption as it was written anyway and kind of affirmed by the recent opinion. So I did take that into consideration. It was certainly more helpful to have that opinion than it would have been not to have it.
Well, I think we're in deep ground in the decision you make today. We make today needs to stand. I'm one of those, if it's good for one, it's good for everybody, and I want to be consistent the way I vote, but now, you've got me confused.
Anything I can do to answer any questions or do
Right. It's deep for me.
Gentleman, lady, any comments?
Based on the information that Julie has presented, it looks like there probably was a violation under, and that the exemption under 6213-104, it's A6 in my book. I don't know if I've got an earlier version of the statute.
It's been renumbered. It's A1F. I'm not sure if
The language, I think, is the same as what you read a minute ago. Initially, it would look like the
it was
exemption
reworded for the vacation lodging, which is the rest of it. Not really related. I think it was just renumbered.
Okay. Well, it looks like the exemption initially would apply, which would mean there would be no violation because you would say, well, you had a corporation acting through an officer duly authorized to engage in such real estate transaction where the transaction occurs as an incident to the management, lease, sale, or other disposition of real estate owned by the corporation. That sounds like what we had, and so you would think there would be an exemption. But then the exemption goes on. It says, however, this exemption does not apply to a person who performs an act described in 6213-102A4A, either as a vocation, which I don't think we have evidence of a vocation, or for compensation if the amount of the compensation is dependent upon or directly related to the value of the real estate with respect to which the act is performed. It sounds like the person probably does receive compensation based on the sale and based on the value of the real estate since they're receiving a distribution of profits. So that makes it sound like the exemption doesn't apply and there was a violation. So unless I get some additional argument or facts that lead me otherwise, that's where I stand right now.
And there's a chance that this person won't sign this consent order. It could go to a formal hearing. I guess this would be an unlicensed case, which you all had authorized to be before an ALJ sitting alone. But if this is the type of case that you all want to specify, if this goes to a formal hearing, we want to hear it. We want to be the ones that, because you are just making this based on a probable cause determination at this point. It may be something like Commissioner Alexander said, this is, he said this is kind of a big deal, and if it's something that goes to a formal hearing, it may be something you all decide you do want to hear instead.
Stevenson.
Mr. Chairman, I feel so like Commissioner Alexander, but after hearing the opinion of our legal counsel plus Commissioner McMullen, both of them, I'm not going to go against the what they feel like has occurred and what has happened, so I'm ready to vote.
Can I just ask a question?
You sure
Sir?
can.
Okay, so the exemptions are that he didn't receive a commission, he is the president, but he's not salaried, and it's not a vocation.
I'm not making the determination it wasn't a vocation. I don't know that how often this is done. I know it was done twice in one day on a given day. I mean, I'm not convinced that prong is passed either, but we know for certain, or at least if this person's attorney is advised correctly, that this person is not compensated through a salary and that this person does run this corporation. I was given no indication. I asked if this person was paid on a distribution or if this person was salaried, and was merely told they were not salaried.
I mean, the three tests we have not been met, isn't that right?
It's an either or. It doesn't apply if it's either a vocation or if it's dependent upon the compensation of the.
There's not on the HUD, he didn't get any commission.
I have a HUD, there's no commission
And
outlined
there's
on
an
it.
indication from his attorney, he doesn't get paid.
Doesn't get paid a salary.
Yeah.
I think the answer on the salary question from the attorney sounds like it was a little bit cute to me. He was asked, does he receive a salary, which you would think would be a flat, X dollars a month or something like that, or does he get paid a percentage of profits? Is that the way you worded it? Distribution of profits.
I said a distribution of profits or salary. Is it this or this? And I just got.
And they just answered half the question. So to me, I think you could infer that he is getting paid a distribution of profits, because they certainly didn't deny that, and you've offered it as one or the other, and they just denied one. They didn't talk about the other.
Is this a wholly owned corporation by one person?
I'm not sure of that. I had asked the specific role and was told this person was the president of it, but I went back and forth with the attorney. I don't think that I don't have that.
What state's it registered in?
Tennessee.
Corporation.
Tennessee.
All right, other discussion. The motion on the floor is that we accept council's recommendation. Further discussion.
Roll call vote.
Let's take a roll call vote. Ms. Maxwell.
Stevenson,
Yes.
DeChara,
Yes.
Grease,
Yes.
Collins,
No.
Bloom,
Yes.
McMullen. Yes. Alexander.
Yes.
So there, and Flitcroft and Franks are absent. So there's 6 in favor and 1 not in favor. So the motion would pass.
And just as a reminder to the audience, Ms. Kropp will take this decision to the respondent, and he or she will have an opportunity to say, okay, I'll take it, or ask for a formal hearing. That's the process. Next item, please, number 2.
2014-002551 Complainant states that respondent, an unlicensed individual, advertised a home for sale as rent to own, showed the property twice to complainant, wrote a contract for complainant's signature, and accepted a payment of $1,000, which was to be credited toward the first rent payment. Complainant states that respondent also requested an additional amount a couple of weeks later, but complainant saw that the homeowner had not packed when complainant went to the property. Complainant requested the $1,000 to be returned, but states that respondent and the homeowner refused. Complainant attached a receipt signed by respondent, a copy of the cashier's check and money order made payable to the homeowner, and a copy of the lease purchase contract, which does not reference respondent. The address of the home listed on the contract is in a neighboring state. Complainant also attached copies of online advertisements for several properties within the state of Tennessee, which were advertised by respondent and not owned by respondent, according to a search performed by the Office of Legal Counsel. Respondent sent a response stating that the down payment was non-refundable according to the contract. Respondent states that respondent was friends with the homeowner and was simply assisting the homeowner in showing the home. Respondent states that respondent intends to obtain proper licensure in this state and has ceased and desisted all activities to the extent they may violate the Broker Act. Respondent submitted a letter from the homeowner who states that there was no promise of payment to show the home, and respondent was only showing the home because the homeowner was working late hours. The homeowner states that respondent received no payment. The homeowner also states that the down payment was given directly to the homeowner, and the respondent was present as a witness and had a receipt book. The property primarily complained of by complainant is in another state, and it appears from the statement of the homeowner that respondent did not receive and had no expectation of receiving compensation for whatever services were provided. However, it does appear that respondent advertised multiple properties in Tennessee which respondent did not own. It is recommended that this matter be dismissed and an additional complaint be opened against respondent regarding possible unlicensed activity relating to those listings. So the recommendation is to dismiss this matter and open an additional complaint regarding the Tennessee listings specifically.
Move to accept council's recommendation.
Second.
Motion by Commissioner Bloom to accept council's recommendation, seconded by Commissioner DeChara. Is there discussion? All those in favor of the motion, please vote aye.
Aye.
Those opposed, no. It's unanimous. Number 3, please.
2014-003101. Complainant, a licensed broker, states that neither respondent, affiliate broker, inactive license, nor respondent's company are licensed, and complainant states that respondent is engaged in property management. Complainant attached a copy of a letter from respondent to complainant's clients, the owners of a neighboring property, which in part states that respondent manages a property next door, describes the individuals in the property as my tenants, and refers to the property as one of my units. Complainant states that respondent is not the owner of the property. The Office of Legal Counsel conducted a search of the property address and confirmed that respondent does not own the subject property. Respondent submitted a response stating that respondent oversees a few residential properties for the homeowner, and respondent's duties are to handle repair calls, oversee yard maintenance, submit notices to tenants for noncompliance of the lease between tenants and homeowner, take photos of damage, maintenance repair, change locks, perform inspections, and clean paint vacated property. Respondent states that respondent sent the letter to complainant's clients, who are neighboring homeowners, on behalf of the homeowner, and respondent states that respondent's words were not political correct. Respondent states that respondent's affiliate broker license is going to be in retirement once respondent completes education, and respondent's former clients were advised to find another management company or have rent sent to them, advertise their own properties, and negotiate their own leases. Office of Legal Counsel confirmed that respondent's license is currently in active status and inactive status, and respondent's company has never been licensed with TREC. Office of Legal Counsel also performed a Google search of respondent's company name and found web pages listing respondent's company with respondent as the contact person, advertising property management services for a fee, including leasing, negotiating contracts, and collecting rent. The recommendation is a consent order for $2,000 for violations of Tennessee Code Annotated Sections 6213-312B14, 6213-309A1A, and 6213-318B4, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order. You'll notice those are different statutes than are typically cited for unlicensed individuals. That's because this person does have an inactive license. 309 refers to not having a firm license. 318 refers to not engaging in activities under the definition of broker with an inactive license.
Ms. Crop, is that the most we can find?
Let me double check.
Could we do 1,000, 1,000, 1,000?
B14, I've cited because 309 does not have its own civil penalty range within our rule. The range for a violation of B14, which is violation of any provision within the Act, is $50 to $1,000. The reason that's on there, like I said, is 309 does not have a specified range. 318 actually does not have its own specified range, so I'm referencing B14 because it covers a violation of any section. So if you were to take the maximum, attributing it to 309 and the maximum for 318, I believe that would be $2,000. Here, we only have evidence that it's one property. I see an advertisement too. You all could consider that as a separate violation, but I'm not really sure about that. But as far as for the two violations cited, it would be $1,000 for each, I believe.
Motion to approve council's recommendation.
Is there a second?
Second.
Seconded by Commissioner Bloom. Discussion. So let's say, I don't know this answer, Ms. Maxwell, or can this guy go ahead and retire his license before this complaint is handled? It's inactive now.
He would have to complete his education before he could retire his license. I mean, he could go ahead and retire it, but he would still have a license. I mean,
Yeah,
I think that's Ms. Props.
This doesn't go away. I mean, if this license goes into retirement, you all can still hear this. You're still not permitted to engage in any act under 102-4A if you're in retired status. It's just that this person happens to be in an active status, so I cited B4 as opposed to A4 of the same rule. If this person has a retired license, they still have a license for you all to consider this on, so.
Okay. Other discussion? You've heard the motion. Commissioner DeCharo, seconded by Commissioner Bloom. All in favor of the motion, vote aye. Aye. Those opposed, no. It is unanimous. Number 4, please.
2014-003861. Trek open complaint based on information received from a licensed principal broker who reported that respondent, principal broker suspended license, was the selling individual for a property listed by the reporting principal broker's firm. That licensed principal broker states that the property closed in January 2014, and the licensed principal broker learned after closing that respondent's license had been suspended for several months. The licensed principal broker provided a settlement statement from the closing which shows that a commission was paid to the real estate firm where respondent was principal broker. Firm expired in September 2013. Additionally, executed documents relating to the sale, specifically a purchase and sale agreement, lead-based paint disclosure, compensation agreement, and confirmation of agency status, were provided, which list respondent as the selling licensee. Respondent did not respond to the complaint. In addition to failing to respond, it appears as if respondent was engaged in unlicensed activity while respondent's license is suspended and also while respondent's firm license was expired. Recommendation was a consent order with $3,000 civil penalty for violations of Tennessee Code Annotated Sections 6213-312-B14, 6213-309-A1A, 6213-313-A2, 6213-103, and 6213-301. Said order to also include an order to cease and desist all unlicensed activity.
Mr. Bloom, don't you want to ask the same question about this one as you did the last?
Indeed, I would. Is that the most we can charge?
The maximum for B14, which ties to 309 and 313, is $1,000. You could do $1,000 for each, so I guess it could be up to $4,000. However, Ms. Maxwell just reminded me, and this has been updated since I prepared this and finalized it at the end of last week, this person is now revoked. So as far as proceeding, I do have both unlicensed activity statutes quoted in here because this ultimately is unlicensed activity. I also cited 309 because the firm license was expired when all this occurred, and 313 for failing to respond. It's possible at a formal hearing an ALJ could only proceed maybe under the unlicensed 2 statutes because this person now no longer has a license, was revoked for the E&O matters. But for these 4 that are cited here, you have authority to do $4,000. It probably will not get satisfied. It will probably go to a formal hearing, though.
I'd like to recommend that the recommendation be changed to $4,000 in civil penalty.
We have a motion by Commissioner Bloom, seconded by Commissioner McMullen, that council's recommendation be adopted with the exception of increasing the civil penalty to $4,000 from $3,000. Is there discussion on the motion? Let's vote. All in favor of the motion, vote aye. Aye. Those opposed, no. It is unanimous. Number 5, please. Ms. Crop?
2014003961. Complainant hired respondent broker to lease complainant's property. Complainant states that respondent collected rents for February 2012 and September 2012, but failed to forward payments to complainant. Complainant also states that respondent held the security deposit collected from the tenant. Complainant further states that the tenants damaged the property and included receipts for costs of repair. Complainant further submitted a copy of a check from a tenant made payable to respondent, which appears to be endorsed by respondent. Complainant also submitted complainant's bank statements as evidence of money received. Respondent submitted a response stating that respondent continuously deposited rents collected into complainant's account. Respondent states that it was brought to respondent's attention twice that rent was not deposited and the issues were corrected. Respondent further states that the agreement provided for respondent to receive the first full month's rent as a fee for acquiring a tenant and 5% of future rents. Respondent states that funds for the prorated first month and second month were deposited to complainant, and respondent has no record to show that the tenant paid a security deposit. But even if a security deposit was paid, it was a fee that respondent earned per the management agreement. Respondent states that complainant never provided proof that respondent owed complainant money for rents collected via canceled checks from the tenant. Respondent also states that respondent's attorney provided proof to complainant's attorney that these payments were made. Respondent further states that 2 deposits were made in May 2012, one for the May 2012 rent and the other for the missing February 2012 rent. Respondent also states that the September 2012 rent was deposited in October. Respondent provided a copy of the property management agreement, which was between complainant and respondent, who is referred to as manager without any apparent reference to respondent's firm. The agreement states, owner agrees to pay the manager, an amount equal to the first full month's rent as a fee. Respondent also submitted a copy of a residential lease contract for a 12-month term beginning June 2011. The lease provides that a deposit is due at the execution of the lease. Respondent provided a printed bank deposit slip from 5/21/12 for what is stated to be February's rent into what appears to be complainant's bank account, as well as a deposit slip on 10/24/12 for what is stated to be September's rent. Complainant submitted an additional response stating respondent did pay twice in May, but also missed June's rent payment in addition to February and September. Complainant submitted deposit slips showing deposits for January, February, March, April, May, July, August, and October. Bank statements indicate that the tenant paid complainant directly for November. It appears that, even based on respondent's own admission of depositing February 2012 rent in May 2012 and September 2012 rent in October 2012, respondent did not timely remit money owed to complainant, which should have been remitted to complainant by the 10th of the month collected per the management agreement. However, the documentation provided does not show that all months' rents were paid to complainant, because although respondent states that the February rent proceeds were paid in May and September proceeds were paid in October, complainant's documentation suggests that, if this is true, there is no proof of funds paid for June 2012 and October 2012. Further, the management agreement between complainant and respondent, combined with the September 2012 rent check from the tenant, made payable to respondent and endorsed by respondent, indicates the respondent was being compensated by someone other than respondent's broker for real estate activities. Respondent stated that respondent originally kept the September 2012 rent payment for complainant terminating the management agreement early without written notice, but respondent later deposited that money back into complainant's account in October, which would appear to indicate that respondent accepted compensation directly, not through respondent's broker, and would also suggest that the money was not kept in an escrow account pursuant to the deposits and earnest money rule. In response to a request for additional accounting documentation and check copies, respondent states the respondent cannot provide the information because it was misplaced during a firm change in 2012. This appears to be a failure to maintain documentation. Finally, it appears that the failure to collect the security deposit pursuant to the lease provisions constitutes a failure to be loyal to the interest of the client. Therefore, the recommendation It's a consent order for $2,500 for violations of Tennessee Code Annotated Sections 6213, 312B5, 6, 11, and 14, and 6213, 4042, as well as Rule 1260-02-.09, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order. I'll
Just
answer
one
questions.
point of clarification. Did you say 2,500 or 2,000?
I'm sorry, 2,500, what's typed in there. When I sent out these, when we sent out the drafts to everybody for pre-review on Friday, I had requested more documentation. And that's when I received confirmation back that this person was not apparently maintaining records as required by, or had misplaced records in a firm change and was not maintaining records for 3 years as required by 312B6.
Commissioner Bloom, do you have a question?
Well, I don't know if we can charge for 6213, 312.5, but we can 6, 11, and 14. Is that not right? $1,000 on each one of those three.
The maximum for 5, are you saying you're not sure you see a violation of 5?
No, I see a violation of 5, but in my book it says deleted by the 1988
No,
amendment.
they may not have, that rule has been corrected. We need to, is it in their pocket part? That is an older rule that we had cleaned up. I think somehow in the past it had gotten offline and the numbers were not matching up. Our current rule with civil penalties, I can tell you the maximum for each, is that what you're looking for here?
Yes, ma'am.
For 5, the maximum is $1,000. For 6, the maximum is, well, I'll just tell you, for 5, 6, 11, and 14, the maximum is $1,000. There's not an amount assigned to 4042, so that one is counted
I'd
as
like
1,000.
to recommend that the violation amount be changed to $4,000.
And there's also, you can do 1,000 for the rule as well.
Well,
but-
then make it 5. Until we get the attention of people so that it
I was just
costs
pointing
them
that out
more money
because-
to do this than it does to pay the fine.
No, I was just
they'll
wanting to let you
continue
know
to do
that
it.
there is a specific range for a violation of any commission rule or order, and the maximum for that is 1,000. So I was just pointing out that that
I'd like
does
to
have
change
its own
that to
range.
5, thank you.
I'll second.
I have a motion from Commissioner Bloom, and his motion is to accept council's recommendation with a civil penalty adjusted from $3,000 to $5,000. The balance of the recommendation from council remains the same. Commissioner DeChara seconded that motion. Is there discussion on the motion? Let's vote. All in favor of the motion, say aye. Those opposed, no. It is unanimous. I'll just take a break just for a second, Julie. To the audience, part of what this lady does is assemble all this information over a fairly short period of time and then put it into a narrative that is understandable to her, first of all, but more importantly to us. And to dumb it down for us to understand it sometimes takes some effort.
I'm reading slower today, though.
It's a real skill that she possesses, and it's important to us to get it right, and we appreciate her effort in that respect.
You ready for the
Number
next
6.
one? 2014-003991. A complaint was opened against respondent, principal broker, on a potential failure to supervise issue regarding the previous respondent broker in complaint 2014-003961, hereinafter called broker. Respondent responded to the complaint stating that it is respondent's belief that broker has done no wrong and has documented how the money was handled. Respondent states that broker only did what was agreed in the lease, and this matter has been going on for over 2 years. As stated above, in response to a request for additional information, neither respondent nor the broker were able to provide further accounting documentation and/or check copies due to documents being misplaced during a firm change in 2012, which appears to be a failure to maintain documentation. Also, it appears that the funds in this transaction were not kept in an escrow account pursuant to the deposits and earnest money rule. The recommendation is a consent order for $2,000 for violation of Tennessee Code Annotated Sections 6213, 312B6, 14 and 15, 6213, 321, as well as Rule 1260-02-.09, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order.
So could that be reflected to be 4, if I'm looking at that right? 6, 14, 15, and then one more 1,000 for the the rule?
Yes, sir, because 321 doesn't have a defined range, so that's why
Right.
14's in there. So
Right.
you're correct. It would be 1, 2, 3, and then 4
Well,
for the
That
rule.
would be my motion.
Yes, sir.
To accept the recommendation with the consent order change to $4,000.
Second.
You've heard the motion. It's to accept council's recommendation with an increase in the civil penalty to $4,000. Offered by Commissioner Bloom, seconded by Commissioner DeChara. Discussion. Let's vote. All in favor of the motion, vote aye. Aye. Those opposed, no. The vote is unanimous in favor. Number 7.
014-004231. Complainant states that respondent, unlicensed individual, is managing and renting 7 units in a condo building without a license and provided a link to the advertisements. The advertisements attached are for nightly vacation rentals. Respondent submitted a response through an attorney. Respondent's attorney states that respondent is not engaged in unlicensed real estate activity. Respondent's attorney states that respondent is the owner of the unit in the advertisement, and the other units referenced are respondent's neighbor's units. Respondent's attorney states that respondent may from time to time show the units or assist the homeowners in their transactions, but respondent does not negotiate security deposit amounts or rentals for any property other than respondent's own. Complainant states that the listings on the website show rate and security deposit information, and the tab that states email the manager sends an email to respondent. Complainant states that complainant spoke to a representative from the website who stated that in order to list information on the website, either respondent had to have an agreement with the property owner or to list the property on respondent's page, or respondent has to post and pay for the listing. Complainant also states that respondent is collecting a commission. Did receive additional information from this complainant today, and my office had found this information online as well. The complainant points to a website that the complainant located. Well, first the complainant states that this person obtained a business license in the county where they're operating in January, and also has a website. I won't give you the name of the company, but it's a, something properties. It's a company name, and it talks about renovating and living in a unit, but then also having vacation rentals, and says, I have taken on managing 3 additional lofts in the same building, which it goes on to then state are not owned by this person. So the issue here is an unlicensed vacation lodging service. The recommendation is consent order for $1,000 for unlicensed activity in violation of Tennessee Code Annotated Section 6213. 104B, stating that each vacation lodging service shall be required to have a vacation lodging service firm license, and B3BI, stating that each vacation lodging service firm shall designate an individual to be licensed as a designated agent.
Is that the maximum?
That statute subsection does not have a specified maximum, but under 561308, which authorizes violations in the maximum of 1,000, I think since they're 2 subsections of the same statute, 1,000 might be the maximum we could go under for that. So it's separate from the other unlicensed activity statutes.
Still hadn't found a place for them to go, though, have you?
It's under 104, and it specifically excludes all of our other statutes, so I'm limited to that one.
I make a motion, we accept council's recommendation.
Second.
Motion by Commissioner Stevenson, seconded by Commissioner Alexander to accept council's recommendation. Discussion. Let's vote. All in favor of the motion, please say aye. Aye. Those opposed, no. Motion passes unanimously. Let me ask Commission's thoughts just for a minute. We have 20 of these cases today. We're almost halfway through. Do you want to take a break at number 10? And then finish
That'd be good.
Do you want to take it?
I'm not a commissioner, but
Would you like to take it at number 8, Julie?
whenever you all are ready. But if we could have a break before the end, that would be great.
Let's take a 10-minute break.
We forget babies.
Oh, I got this worked out now. I got me.
Look at you. All right. Let's get back in session.
Mr. Chairman, I didn't want to have to get on you like I did him all the years, so I'll do better.
I thank you for your cooperation.
Why didn't you do that a year and a half ago?
There's a lot of difference in the 2 people I had to put up with.
All right, let's order. A little decorum, please. Ms. Crop, we're ready
I'm
to go. Number 8.
Number 8, 2014-004371. Complainant states that respondent, unlicensed individual, and respondent's company are unlicensed but are performing property management services. Complainant states that respondent retained rent checks and security deposits for properties located in Tennessee. Complainant submitted screenshots of respondent's website, which advertises services such as tenant placement, marketing and advertising, and property showings, rental owner statements for multiple properties, and exclusive leasing management agreements for 2 properties. Respondent did not respond to the complaint. The recommendation is a consent order for $2,000 for unlicensed activity in violation of Tennessee Code Annotated Sections 6213-103 and 6213-301. Said order to also include an order to cease and desist all unlicensed activity.
Mr. Chairman, so move.
Second.
Motion by Commissioner McMullen to accept council's recommendation and seconded by Commissioner DeChara. Discussion. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Vote unanimous. Number 9, please.
14004411. Complainant signed a contract to purchase a lakefront lot and provided an earnest money check. Respondent, affiliate broker, was the listing agent for the seller. Complainant states that the listing promised year-round water. Complainant states that by October, the water in the cove dramatically dropped and the water was gone beneath the boat lift. Complainant sent a letter stating that complainant would not be closing on the property and received a response requesting earnest money be delivered to the owner and requesting that complainant pay half the closing cost. Complainant states the respondent misrepresented the property. Complainant also states that the purchase and sale agreement provided that an owner finance agreement would be presented prior to closing for review and acceptance, and complainant states that a financing agreement was never signed. Complainant states that the earnest money issue is resolved and the earnest money was split. Complainant further states that the MLS listing still claims year-round water. Complainant submitted copies of listings which state minutes from Yacht Club, it had the name, and year-round water on the main channel. Complainant also submitted photos which were stated to be taken in mid-November where there is no water beneath the boat lift. Complainant submitted an answer to the complaint stating that complainant was an unrepresented buyer, and respondent submitted a purchase and sale agreement, disclaimer, agency representation agreement, and lot land disclosures. Respondent states that respondent reminded complainant of inspection rights and due diligence period, but complainant chose Part G of the contract with no inspection contingencies and accepted the property as is. Respondent also states that respondent reviewed the disclaimer language with the complainant that acknowledged that buyer and seller have not relied upon advice, casual comments, and verbal representations relative to the matters. Respondent states that since the contract referenced owner financing, an attorney was asked to prepare a promissory note and deed of trust, and respondent states that respondent was not informed that complainant wanted changes to those documents. Respondent states that complainant called mid-November and asked about the neighbors clearing brush, but it was determined that the neighbors were doing so legally and within their boundary lines. Respondent states that complainant did not mention the water line but made a verbal offer to reduce the property price because complainant felt that the property had lost value due to the neighbors' renovations. Respondent states that the seller declined and closing instructions were sent to both parties. Respondent states that a letter to cancel the contract due to a water issue was presented to the seller, who found the claim unfounded because complainant visited the property multiple times and already owned property in the subdivision and was a boat owner who would have been familiar with the customary drawdown of the water levels in the fall. Respondent states that complainant did not show up to closing, a mutual release of earnest money was presented but not signed, and an interpleader was filed. Respondent further states that the neighborhood dock and yacht club offers year-round water, but the language does not state that the property dock offers year-round water. Respondent states that the complainant seemed to be offering excuses to get out of the closing, and respondent's client, the seller, requested that respondent hold firmly to the original contract.
Second.
Motion by Commissioner Collins, seconded by Commissioner McMullen, excuse me, to accept council's recommendation and dismiss this complaint. Is there discussion? Let's vote. All in favor of the motion, please vote aye.
Aye.
Those opposed, no. Motion carries.
2014-004421. A complaint was opened against this respondent, principal broker, on a potential failure to supervise issue regarding the previous respondent, affiliate broker, in complaint 2014-004411 above, hereinafter affiliate broker. Respondent responded stating that the affiliate broker submitted the purchase and sale agreement documents and earnest money, which was deposited into the company's escrow account. Respondent further states that all agency and contract documents were executed in a timely manner, submitted to respondent, and processed by staff. Respondent states that the affiliate broker notified respondent that the previous complainant and the seller could not come to an agreement regarding the earnest money, and the previous complainant requested the contract be canceled. Respondent further states that an interpleader action was filed within 20 days, and the judge split the earnest money 50-50 after a hearing the following month. Respondent further states that respondent reviewed the previous complaint with the affiliate broker regarding the advertising. Respondent states that the affiliate broker advertised the property per the owner's instructions, that the previous complainant owns property in the community and is aware that the property is minutes from the yacht club and there is a year-round water on the main channel. Respondent states that the affiliate broker is an excellent agent and attends all meetings and educational classes on a regular basis. The recommendation is to dismiss.
Mr. Chairman, so move.
We have a motion to accept council's recommendation from Commissioner McMullen, seconded by Commissioner Collins. Discussion? Let's vote. All in favor say aye.
Aye.
Those opposed, no. Please put me down as a abstain. Recuse. I think I'll recuse on this one. Thank you. Number 11.
2014004461. Complainant hired respondent, affiliate broker, to assist in purchasing a property. Complainant states the complainant was informed that complainant was pre-approved, signed a purchase and sale agreement, paid for the required inspections, and began moving out of a rental property in preparation for the November 18th closing. Respondent states that on November 15th, complainant was notified that complainant needed to have the spouse's car transferred out of complainant's name to qualify. Complainant was notified on November 16th or 17th that complainant did not qualify for the loan alone and needed to process the application with complainant's spouse. The loan was denied on November 18th and closing did not occur. Complainant states the complainant does not understand how this happened, and respondent and the loan officer each blamed each other for the problems. Complainant states that respondent misrepresented complainant's interest by providing complainant with untruthful and misleading statements, and complainant feels that there was a close relationship between respondent and the loan officer, which was a conflict of interest. Complainant states that complainant does not understand how all of the chaos occurred, with complainant losing complainant's current rental and paying for inspections and a closing date being scheduled when the loan approval had not already been confirmed. In early December, complainant states that complainant requested the earnest money back and states that respondent never deposited the earnest money check into the firm escrow account. Respondent submitted a response through an attorney. The loan officer also submitted a statement that the allegations against respondent are unfounded, and that the loan officer advised complainant in a phone conversation that complainant should be looking for a house within a specific range, and complainant called a few days later stating that a home was found and a formal loan application was made. The loan officer states that the mortgage rate lock disclosure was mistaken by complainant as a loan commitment letter. The loan officer states there may have been a proposed closing date between the buyer and seller, but the closing was subject to loan approval, which had not been issued. The loan officer states that complainant misrepresented the value of complainant's out-of-state home and indicated higher earnings than what complainant's employer verified, which led to the loan denial. Respondent states that while looking at houses, respondent gave complainant the name of 2 different lenders to contact, and there was no affiliation with the loan officer and respondent. Respondent states that respondent requested a number of inspections and appraisals, some of which have not been paid. Respondent states that a closing time was set up with the title company for a targeted closing date in the contract, but respondent said in an email on November 15th from the lender, from November 15th from the lender stated that there was no loan approval yet. Respondent further states that despite many requests, complainant did not write an earnest money check until November 15th, and the office policy is that a check cannot be deposited within 10 days of closing. Respondent states that the cashier's check was requested so that it could be deposited and credited at closing, but complainant only provided a personal check. It appears that a cashier's check was never provided, and the personal check was voided after the transaction fell through. Respondent states that the closing did not occur due to false statements provided to the mortgage company. Respondent states that respondent was loyal to complainant's interest. Respondent submitted a copy of the transaction file along with a copy of complainant's personal check for earnest money. Also included was an earnest money disbursement and mutual release of purchase and sale agreement, which provided that the money be returned to complainant due to inability to obtain a loan, and signed by complainant. Complainant submitted additional information stating that the difference in income was for projected bonuses. Complainant states that complainant was not asked for a cashier's check for earnest money. Further, complainant states that complainant does not want respondent to get in trouble and that complainant would use respondent as a realtor again. However, complainant states that complainant only wanted questions answered and is trying to understand if it is normal process to go through the motions of closing, even though a loan had not yet been approved. And the recommendation is to dismiss.
A motion by Commissioner Collins, seconded by Commissioner McMullen, that we accept council's recommendation and dismiss this complaint. Is there discussion? Let's vote. All in favor of the motion, say aye. Aye. Those opposed, no. Motion passes unanimously. Number 12.
2014004501. A complaint was opened against this respondent principal broker on a potential failure to supervise issue regarding the previous respondent affiliate broker in complaint 2014004461 above, hereinafter affiliate broker. Respondent submitted a response stating that it is respondent's understanding that the
Motion to accept your recommendation.
Second that.
We have a motion by Commissioner Collins to accept council's recommendation and dismiss this complaint against the principal broker, seconded by Commissioner McMullen. Mr. Collins, I suspect you made this motion because we dismissed the previous. Is that?
It could have been.
I did suspect it. I didn't fully commit to it, but is that Mr. McMullen?
I seconded it.
That's what you seconded. Okay, I just want to make sure.
My memory is basically because Austin punched me.
You guys need to reverse roles occasionally so I can go to.
But I'd like to remind all the licensees, this complaint report, this legal report, has been sent to all of us. We've had an opportunity to review it previously, so sometimes it's not necessary to completely read through all of the documentation that Julie has put together.
The reason we read it out now is so the commission can discuss it. You've all
Right.
individually had the opportunity to read it. Just now's your opportunity to discuss it. So that I think is what.
In this particular case, the source of the discussion was found not to be worth discussing.
Exactly right.
So neither is this and that. Have we voted? Let's vote on this. The motion is to dismiss per council's recommendation. All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 13.
2014004911. Complainant was a purchaser of property and respondent affiliate broker was complainant's agent. Complainant states that before closing, complainant asked respondent where the property line was and respondent stated everything inside the fence. Complainant states that after closing, respondent gave a key to a storage unit located on the side of the property. Several months after closing, complainant states that complainant received a notice that complainant had not paid property taxes and the property would be auctioned later that month. Complainant states that it was discovered at that time that the fence on complainant's property is also on a parcel of land not belonging to complainant and the storage unit is outside complainant's property. Complainant states that respondent stated that respondent was sorry and assumed the property inside the fence was one lot and was not aware it was two lots. From the documentation submitted by complainant, it appears the purchase was an REO and it appears that complainant only purchased a parcel identified as Lot 1. Lot 2 does not appear to be referenced in the deed or title policy. It appears that Lot 2, not owned by complainant, is the lot which has delinquent taxes. Respondent submitted a response admitting that respondent told complainant that the property inside the fence was included in the sale according to the MLS listing, but that complainant could get a survey done to be sure, and respondent states that complainant did not do so. Respondent states that complainant's biggest concern was to close quickly, and respondent followed complainant's instruction. Respondent states that respondent notified respondent's principal broker, who was the listing agent of the property. Proper notices of agency status were included, and the closing agent for the title company. Respondent states that respondent is sorry that complainant is having this issue, but respondent is no longer with the same firm as respondent was at the time this took place, and respondent feels that respondent's previous principal broker should address the situation. Respondent submitted a copy of the listing, which noted acreage in the same amount as listed on the tax assessor's website for Lot 1, and the remarks state the property is sold as is. Additionally, an addendum signed by complainant and seller states in part that the seller acquired the property by foreclosure, deed in lieu, forfeiture, tax sale, right of eminent domain, or similar process, and the purchaser acknowledges and agrees to accept the property in an as-is, whereas condition. The recommendation is to dismiss.
So move.
Second.
Mr. Alexander makes a motion to accept council's recommendation. Commissioner DeChara seconds that motion. Is there discussion? Mr. Stevenson.
This has nothing to do with discussion on this, but it just
Let's not talk about it.
brought to my attention. Has anybody heard about a
Can we
law?
vote on this motion?
Go ahead.
Let you have it.
Go ahead.
Is there other discussion relevant to the motion on the floor?
It might be, it might be relevant.
Let's vote. All in favor of the motion, vote aye. Aye. Those opposed, no. Ayes have it. Mr. Stevenson, you're
Yeah.
recognized.
The,
Can we recognize him after this?
is any,
I'm pushing my limit.
are any of you aware of a law that was having to do with surveys and real estate closings
What about it?
that were supposed to have gone into effect on July the 1st? Surveyor showed me a copy of a statute. Tennessee. Well, evidently, you haven't heard about it. I'll bring a copy of it next month.
It's a.
What if you're not here next month?
The surveyor has to look at, I'm coming back. Even if my replacement is named, I'm still coming back just to aggravate y'all.
He'll email you a copy.
No, he can't do that.
No, I won't do it. I'll send you a hard copy. But I'll get one. Seriously, didn't know
So
if
what
anybody
is
heard
the
about
law?
it. It just states that a surveyor, for a real estate transaction to occur, that a surveyor has to look at the legal description and render an opinion as to how they feel about its accuracy. I'll bring you a copy. Evidently, y'all don't know anything I'm talking
I think
about.
it's specific to Anderson County, if I
No,
remember.
it's specific to Knox County. No, I'll bring a copy of it.
Anything else, Commissioner Stevenson?
No.
Thank you. Number 14, Ms. Crop.
20140055151. Complainant, a licensed agent, states that a listing was posted by respondent, affiliate broker, on at least Zillow, Trulia, and HotPads, but was a phantom listing for a house that doesn't exist. Complainant states that a client called and was excited about the listing at a too-good-to-be-true listing price, and complainant found no record of the address on RealTrax or the tax records. Complainant states that there was no such house or address. Complainant states that when complainant inquired about the property listing, respondent sent a response stating that there were still a couple of lots left and this home is to be built, and the pictures were from a house which was built for a client elsewhere. Complainant states that this is a phantom listing, so respondent could obtain leads. Respondent submitted a response stating that this is not a phantom listing, but respondent attempted to assist another agent in marketing property under the residential category to increase the volume of interest in the property. Respondent states that these ads seem too good to be true, but respondent can provide a list of happy clients that will attest the amount of equity earned. Respondent submitted a listing addendum form that would be signed by the builder, attesting the builder is capable of building a home on the proposed lot for the price advertised. Respondent states that respondent's email response to complainant clearly states there are multiple lots that can be built on, that the property is not there yet, and the property is to be built. Respondent states that this was not misleading advertising. Respondent also states that the websites given were auto-populated and not always current, and respondent is not responsible for the content posted on those sites. To try to combat this, respondent includes a time frame in the ad stating when the pricing is good through. Respondent's principal broker also submitted a statement along with another similar ad that states that the third-party website had added, changed, or provided information other than that listed because the property was to be built, but was listed on the third-party website as a single-family home. Principal broker also states that respondent even offered to set up a meeting with complainant and complainant's client to explain how the process worked and to answer additional questions. Respondent's principal broker states that he has and will continue to monitor ads and information so that the public is not misled and understands the products offered. The recommendation is to dismiss.
Motion by Commissioner McMullen to accept council's recommendation, seconded by Commissioner Collins. Is there discussion on this topic? Mr. Bloom?
Well, yeah, I'm just not sure that the respondent is not responsible for the content posted on these sites. Why would he not be? If he's referencing those in his ads.
I think this person is saying that this person doesn't control what Zillow and ads of that type put up on there, and there is a policy stating that licensees are only responsible for first
Oh, it's
generation
referencing the Zillow and Trulia?
Those were the copies of the
Okay.
advertisements
Okay.
listed. Those were examples up there, and so I think that's what they're referencing. And when the principal broker said sometimes these websites take the information and pull them off, I think that's what that, while they weren't referring to a specific one by name, I assume they were referencing the screenshots provided with the
I
complaint.
thought there were some other websites that he was directing him to.
I don't believe so, because those were the screenshots with the complaint, and so I imagine that's what was being.
But they did say that they could build those houses for the price stated in the ads.
The ad the screenshot that I got did not have a price on it, but the person provided a form that was an addendum to the purchase and sale agreement that the builder filled out, and it wasn't an attest, it was where the builder would attest to, it filled in you would fill in the information, it was a form, but they said that it was utilized for properties of this type.
So, this seems a little odd to me that this guy or lady is advertising something that doesn't exist. Is that typical in residential real estate?
Well, in our MLS, it has to be a certain percentage finished before it can go in the MLS, but this wasn't in the MLS. It was just on Zillow, Trulia, and Hot Pads.
Right, and actually, the complaint says for the screenshot that was referenced here for the example property that was given, it says it is not in RealTracs. So it appears that it was just on these third-party websites.
My only question is, for it to get to those sites, they have to pick it up from somewhere. Either that or you have to enter it there, one or the other.
Didn't they say they put it on there themselves?
Well, the complainant is saying that it was posted by the respondent.
The complainant's saying it's on there and it's a phantom listing. The person's name is on it. I'm not sure that. I just have screenshots and it's kind of a disjointed complaint. It says that it's basically on these websites and it references Zillow, Trulia, and Hot Pads, and it just says it references this person as this person's firm as the listing agency and this person as the listing agent. So I guess that's where the person got the information from.
Do you think the advertisement had an address, actual property address?
It has a property address. It's got property details. Again, this is a screenshot, so I can't tell specifically where this is from, but it does not look like a RealTracs listing page. It looks like one from one of the third-party websites. And there's only one there. The response includes an example of a listing report when the principal broker referenced that there was one of a similar type. When you saw that the response, there is a RealTracs listing for a residential property that has an address, and it says that it's a new to-be-built plan and goes into detail on that, and then it attaches a corresponding Trulia advertisement for the same property, which then refers to it as a single-family home. And so I think
RealTracs has to be built and then a subsequent website that
it refers to it as a single-family home. And the picture on the RealTracs report has just a floor plan and it says to be built across it, and there's a photograph on the Trulia page. So I think what they're saying at least is that it's somehow getting pulled incorrectly. And I mean, I'm not a broker, so I don't know. I'm just summarizing what I have here.
I have some problems with the way this is coming across, and I may be missing something here, Julie, but if it's not been built, but yet they're putting it in RealTracs, I would like to know if the square footage and the price is matching what's on that Trulia ad that this complainant feels like is too good to be true.
And I don't, the complainant said that the property that they addressed wasn't on RealTracs. For the property for a different property that I have both of them for, it has the acreage. It does have, did you say you wanted to know if it had square footage in it? It does have dimensions for different rooms.
Does the Trulia ad have an address?
The Trulia ad does have an address and a price. And the Real Tracks for the one that the respondent gave an example has the same price and the same address. It does not have a picture. The Trulia advertisement has a photograph of a house.
I guess if I just had to guess, I guess a complainant wanted to drive by it and see it and couldn't find it, and it wasn't there.
They referenced that there was no such address. I think it was a development that was still in lots and maybe had not been assigned that address yet. Because the response, the reason why it's a little bit disjointed is there's a complaint, then a submitted request to this person, and the response. I don't have a really full listed out complaint. I was kind of having to piece it from a couple places. But they state that they tried to drive by it and couldn't find it, and so they contacted this respondent, and the respondent said there's a couple of lots left. This is actually a property that's located somewhere else, but can be built on any of these lots. That's what I gathered from this.
It'd have to be, the address would have to be a map and parcel number without a house on it.
I think the address on the third-party site didn't have a lot and parcel number. It just had an address, so.
All right, we've kicked this around. Let's see if we're ready to vote. The motion is to accept council's recommendation and dismiss. That was originally made, I believe, by Commissioner McMullen, seconded by Commissioner Collins. Is there further discussion? Let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. The ayes have it. It passes unanimously. Next item.
20140052421 and 2014005422. A complaint was opened against respondents, both are affiliate brokers, for respondents' failure to satisfy agreed citations sent to each respondent for advertising violations. Specifically, Trek received a photograph of what appears to be a directional sign on property, which includes the name of respondent's firm and respondents' names. The apparent violations appear to be that part of the firm name is in a font smaller than that of respondents' names, in violation of Tennessee Code Annotated Section 6213-310B, and the sign does not include the firm telephone number, in violation of Rule 1260-02-.12, subsection 2B. A complaint was opened against each respondent because neither respondent signed and paid the agreed citations. The recommendation is for each respondent a consent order for $1,000 for violations of Tennessee Code Annotated Sections 6213-312B14 and 6213-310B and Rule 1260-02-.12 2B, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of consent order.
Julie, we've already had reviewed this case before?
No, sir, I don't believe so. The agreed citation, I believe this information was submitted into the Commission office, so with typical situations like this, first an agreed citation was sent out for a smaller amount, and this person didn't satisfy that, which is why you're now hearing it. You have not heard it before.
Much time between an offer of agreed citation and failure to pay that citation before it gets to us?
Well, it varies. I take these kind of in the order that they come in, but in this case, it appears that Mr. House mailed the citations in March. They were signed for at the end of March. One was signed for at the beginning of April, and I'm presenting it to you now, and I don't have any documentation that they were signed and satisfied.
Do what?
Sufficient time.
Say that's sufficient time.
Is this the maximum on this?
Technically, if you wanted to assign a range for the violation of 310B, which is the fact that the part of the licensee's name is larger than part of the firm name for under 310B, you could utilize the maximum of $1,000 from B14 for that one, and then there's also a maximum of $1,000 for violation of each rule. So if you considered both of those violations, which were outlined in there, the maximum would be $2,000 for each respondent.
Julie, this was a directional sign, like at an intersection, pointing toward
But
property that was
I know
listed?
it's hard with these. I would call it a directional sign because there's an arrow on it and it doesn't appear to say for sale. It doesn't, yeah, it's a photograph, so it looks like it's in grass somewhere, but it's not, it doesn't appear to be a for sale sign for a particular home. So I take it that it's a directional sign, but it does not merely say for sale this way. The contents of it say for sale with an arrow under it. Then it has the firm name, and it has the two licensees' names on it. And the two licensees' names are bigger than part of the firm name, and there's no telephone number on it.
Violation then.
Does that help answer your question? I'm sorry, I know without a photo it's hard.
Where I read, appears to be a directional sign on property, but this.
Well, it's on a piece of property,
On a piece of
not
property.
for
Okay,
a particular
I
piece.
understand
I'm
that.
sorry, that
Sticking
may
in
be.
the ground.
At an
But the
intersection.
reason I utilize that language is because when you all interpreted 310B, you said a sign on any property, including billboards. So it is a sign that is on property somewhere, so.
Well, I'm kind of like Gary on getting their attention on these citations. If they're not paying them when they're given the first round, then I'm not sure we should be very lenient on the second round. So I would make a motion that we raise the fine to $2,000 per person. And everything else staying the same.
That's the motion. Is there a second? Last call. Is there a second to a motion to accept council's recommendation, however, extend the civil penalty to $2,000? The chair will rule the motion dies for lack of a second. So we're back to council's recommendation. Is there a new motion?
So moved.
Second.
Mr. Alexander moves that we accept council's recommendation. Mr. McMullen seconds that motion. Discussion. Did they reply at all and just say we're not going to pay it, or they just ignored it?
There was no response, and they didn't satisfy. Typically, the only response we get to an agreed citation is somebody signing it and satisfying it. And in most of those cases, you all don't ever see them. And sometimes I'll present them and say this was satisfied after it got to me. But no, I don't have anything. I don't have any record that I could find.
They just ignored you.
I thought that anytime you were offered a agreed citation, you didn't accept it, it automatically went to a formal hearing,
That's it.
no matter whether it was the commission or the staff. Is that not right?
The typical process, since I've been here at least, is it starts as an agreed citation. For the most part, I would say probably about 90% of those are generally satisfied before they get to you all. But the process, I think, for the ones that I've always had is it's presented to you, a consent order is then offered, and then if they don't accept that, then it goes to a formal hearing. So you're not skipping the formal hearing step. It's getting to the consent order stage before you all, because the agreed citation was an opportunity for it to have possibly been resolved without having for it to reach this level.
What?
I said we've done all this work and all of the remapping and verification, so if you're going to enforce it, somebody needs to second the motion.
You've got a second.
It
Commissioner
did
McMullen.
get seconded.
Who?
Commissioner McMullen seconded your motion.
Oh, I didn't.
Yeah. And
You got to speak in the phone, Commissioner.
I just wanted it.
Yeah.
Turn it up.
By the way, we've recently raised the level of civil penalties that staff can offer in an agreed citation for the most part. We did that last month, I think.
Right, but those aren't effective till October 1st.
Oh, okay. Thank you.
That's what you all voted.
All for the question.
Yes, thank you, Mr. Alexander. The motion is to accept council's recommendation as presented. Let's vote. All in favor, say aye. Aye. Those opposed, no. Ayes have it unanimously. Number 17.
2014-005501. A complaint was opened against this respondent, principal broker, who is the principal broker of the previous affiliate broker respondents in complaint 2014-005421 and 2014-005422, hereinafter affiliate brokers, for this respondent's failure to satisfy an agreed citation.
Move to accept council's recommendation.
Second.
Sorry for the interruption, Ms. Crop, but we have a motion on the floor to accept your recommendation without you going into all the detail. Motion by Commissioner McMullen, seconded by Commissioner Alexander. Is there discussion? And again, for the attendees, this refers back to the case we just heard prior to this case. Question has been called for. Any objection? Hearing none, let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. Mr. Stevenson.
Mr. Chairman, could I have permission to address the licensees that are here? This is something else you're going to have an opportunity. Do it after the meeting? I mean, this is just about,
You go right ahead.
part of you being here, for whatever reason, is to learn something. The statute says that the name on a sign, whether the directional sign, we've been talking about these last two complaints, or whether it's a real estate sign in the yard, that the agent's name can be no larger than the letters in the company name.
Smallest font.
The smallest font in the company name, the agent's letters can be no larger than that. And just keep that in mind. If your signs aren't in compliance, you've got till October the 1st.
Oh, no, it's an existing statute.
Right, it's an existing statute now, but I'm just saying, come October the 1st, you're going to start getting.
Bigger fines.
Potential of that agreed citation being for more money.
Yeah.
But your phone, the company phone number also has to be on the directional sign. If your company name is on there, you've got to have your company phone number as registered with the commission, not your cell phone number.
And since we're preaching,
Go ahead, preach on,
the
brother.
principal broker will likely get the same offer to pay the same amount as his affiliate or her affiliate, as you've seen recently in two separate situations. Number 18.
2014-005601. A complaint was opened against respondent, timeshare salesperson, for respondent's failure to satisfy an agreed citation, which was sent to respondent for failure to complete administrative measures for transfer or retirement of license following respondent's release from a timeshare firm. A signed Trek 1 form indicates that respondent was released from respondent's former firm on or about November 17, 2013. Another signed Trek Form 1 indicates that respondent did not transfer to a new firm until on or about March 17, 2014. Respondent submitted a response to the agreed citation acknowledging that respondent failed to submit the retirement fee for respondent's timeshare salesperson license. However, respondent states that respondent did not have the extra money to do so, and the timeshare resorts would not be hiring until the spring. Respondent also apologized for the infraction and asked for the Commission's consideration because respondent states that respondent does not have extra funds and must work to stay current on child support. On or about May 23, 2014, respondent's timeshare salesperson license was placed into suspension for child support. The recommendation is a consent order for $250 for violations of TCA Section 6213-312B16 and Rule 1260-02-.02 subsection 2, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order.
Is there a motion?
Motion to approve council's recommendation.
Motion by Commissioner DeChara, seconded by Commissioner Collins to accept council's recommendation. Is there discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. The ayes have it unanimously. Numbers 19 and 20, ladies and gentlemen.
2014-006211, 2014-006212. Complainants were sellers and Respondent 2 broker was facilitator for the buyers. Respondent 1 is Respondent 2's principal broker. Complainants state that the inspection period should have expired on December 2nd, but the inspection wasn't completed until December 3rd. Complainants state that they did not receive a report and a licensed inspector was not present. Complainants state that they were presented with an earnest money disbursement and mutual release based on inspection contingencies, but they did not sign it. Complainants filed their own earnest money disbursement and mutual release on December 4th, requesting earnest money for non-receipt of an inspection report by a licensed home inspector and the inspection not being completed on time. Respondent 1 emailed on December 10th stating the buyers walked due to factory noise, but complainants state they live 6 to 7 miles away from any business. Respondent 1 emailed on December 28th stating that the investigation into the earnest money was complete, and upon a reasonable interpretation of the contract which authorizes him to hold such funds, Respondent 1 decided to release the earnest money to the buyers. Complainants submitted a letter via their attorney to Respondent 1 requesting that the earnest money be delivered to sellers or requesting filing an interpleader. Complainants state that Respondent 1 emailed complainant's principal broker stating that respondent consulting an attorney and was releasing the earnest money back to the buyers without complainant's permission. Respondents state that they understand complainant's frustrations with packing before the home inspection was complete, though there was a possibility that buyers would terminate the contract. Respondent 1 states that all surrounding events were looked into, and Respondent 1 focused merely on the facts. Respondent 1 emailed complainant's principal broker stating that the most important element in the decision of distributing the earnest money was the home inspection period, which was to be completed by December 2nd. Respondent 1 states that Respondent 2 requested by text a one-day extension on the inspection, and a response of okay was received, leading Respondent 2 to believe that complainant's agent confirmed with complainants and obtained permission. Respondent 1 states that these communications really should have been submitted in writing, signed by the parties. Respondent 1 states that complainants had 3 days to dispute the delay of the inspection period and did not, and that complainants vacated the house for the inspection, and Respondent 1 considered these actions to be implied consent by complainants. Respondent 1 also stated that complainant's agent called Respondent 2 during the inspection and asked if any questions could be answered. Respondent 1 states a belief that the precipitating issue relates to a noise nuisance for what seems to be a quarry operation which was discovered during the home inspection. Respondent 1 states that the noise was not investigated personally, but buyers described the noise and neighbors confirmed that this noise is constant in the area. Respondent 1 states that the property condition report did not disclose the problem. Respondent 1 states that the buyers chose to exercise their right to terminate and immediately notified complainants in writing. Respondent 1 states that after a thorough investigation, Respondent 1 exercised the right allowed by law upon a reasonable interpretation of the contract which authorizes him to hold such funds to release the earnest money to the buyers after attorney consultation. It appears that the earnest money disbursement was requested by complainants, and Respondent 1 began looking into the file and was in constant communication with complainant's broker. Respondent 1 also consulted an attorney before disbursement of the earnest money. For these reasons, it appears that pursuant to Rule 1260-02-.096A, Respondent 1 exercised the right to disperse funds upon a reasonable interpretation of the contract and disperse the escrow money, earnest money, pursuant to Rule 1260-02-.097 without unreasonable delay, and therefore the recommendation is to dismiss.
Move to accept.
I'm going to judge that Commissioner Bloom made the motion to accept council's recommendation, and Commissioner DeChara seconded that motion. Is there discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. The ayes have it unanimously. Ms. Crop.
Last one, 20130-20141. This was presented at the March 2014 meeting. Complainant is the principal broker of a real estate firm, and Respondent, principal broker, was a former licensee with that firm. Complainant states that Respondent resigned Respondent's position on September 17, 2013, and left the office officially on September 24, 2013. Upon Respondent leaving the firm, complainant states that the firm performed an audit of Respondent's computer and discovered that Respondent had copied and taken documents and information belonging to complainant, including but not limited to listing agreements, rent rolls, blank management agreement forms, blank listing agreement forms, client phone numbers, financial spreadsheets, etc. Complainant further states that Respondent contacted existing clients of the firm without permission. Complainant states that Respondent formed a new real estate firm in September 2013 with Respondent as the principal and advertised the business as such. However, as of the date of the complainant states that Respondent does not have a broker license and Respondent's new business does not have a firm license or business license. At the time that complainant filed this complaint with TREC, it appears that a lawsuit was also filed by complainant's firm against Respondent. Respondent states that after giving notice of resignation, Respondent explained to complainant that Respondent planned to start Respondent's own firm. Respondent states that Respondent offered to stay long enough for the firm to find a replacement, and Respondent states that a meeting was scheduled to develop a transition plan. On the day after the transition meeting, Respondent states that Respondent was told to leave immediately and Respondent's employment was terminated. Respondent states that if there was an audit on the date Respondent left, that the audit did not show that Respondent had taken confidential and other information. Respondent states that after the transition meeting, Respondent was reminded of the confidentiality agreement signed years earlier. On that day, Respondent states that Respondent was given a copy, but Respondent was continuing to work on Respondent's business and had many documents on Respondent's personal computer. Respondent states that Respondent did not think any of the documents on the personal computer were confidential or proprietary, but Respondent deleted the documents on Respondent's computer that evening. Respondent states that a few days later, Respondent received a letter from an attorney demanding return of the documents, but as an inventory list of hard copy documents that Respondent had at the time of termination, and that Respondent returned to the firm. Respondent denies that Respondent solicited any clients of complainant after termination. Respondent states that the client contact after departure from complainant's firm was limited to notifying certain clients who complainant had a long relationship or was currently engaged with at the time of departure, but respondent did not solicit the business of those clients. Finally, respondent states that respondent did not take any property listings or execute contracts or agreements with clients prior to receiving respondent's principal broker license and respondent's new firm getting a real estate firm license. Complainant submitted additional information through an attorney outlining the fact that complainant had filed suit against respondent requesting a restraining order, limiting respondent from using any information, documents, etc. of complainant. It appears that the parties entered into an agreed order regarding the same, but the matter is still in litigation. Based on this fact, the matter is currently in litigation regarding a number of potential issues under the Broker Act. It is likely that more information will be uncovered through the course of the civil litigation, which could be pertinent to the Commission's determination of this matter. That time, a consent order for litigation monitoring was recommended, and the Commission voted to accept the recommendation of legal counsel. Since the litigation monitoring consent order was executed, respondent's attorney notified legal counsel that the parties settled the civil litigation matter and provided a copy of the order of compromise, settlement, and dismissal filed in the civil litigation, which provided that the matter was dismissed with prejudice. Respondent's attorney submitted an additional response denying the allegations and stating that respondent engaged in no wrongdoing. The documentation within the file does not appear to evidence a violation by respondent, and therefore the new recommendation is to dismiss.
Make a motion, we accept council's recommendation and dismiss.
Second.
Motion by Commissioner Stevenson to accept council's recommendation, seconded by Commissioner DeChara. Discussion. All in favor of the motion, vote aye. Aye. Those opposed, no. Motion carries unanimously.
That's all I have.
That concludes your report. Ms. Maxwell,
That-
anything else on your agenda today?
No, there is not.
All right. We're not, we're about 5 minutes away, so don't start leaving yet, but attendees, you'll have to sign out. Are there certificates for them to pick up as well?
There's certificates back there.
Okay, Ms. Kimberly will have certificates. Make sure you get one that has your name on it. Mr. Alexander, any commissioner report you'd like to make at this point?
I'm going to wait and see how you perform before I make anything. The only thing I got to say, it couldn't have gotten any worse.
Appreciate that vote of confidence, Mr. Alexander. Commissioner Bloom?
No, sir. I hope everyone has a safe and sound 4th of July.
Commissioner McMullen? Mr. Collins? Pull that microphone.
Hope everybody remembers the 4th of July and what a great country we have to sell real estate freely and have a good 4th.
Mr. Chara?
Well, I'd like to also wish everybody a happy 4th of July. And Ms. Maxwell, can you give us a report on Connell?
He's not back at work, and we don't know when he'll be able to come back. I mean, we hope that he'll be back in some period of time.
Is he improving at this point, or?
We don't know how he's doing right now.
Thank you for that.
But I'll pass on that you all asked about it.
Please do.
He'll be thrilled
Please
that
do.
you did.
All right, Commissioner Stevenson, you get the last word today.
As I said this morning, this commission is in good hands with you and Janet at the helm, and I'll be here next month, even if my replacement is named tomorrow, because I'm gonna come back just to aggravate y'all.
We might want to just file a complaint against you just to get you back.
Hope to see you next month.
All right, ladies and gentlemen, thanks for your attendance. Please be careful going home.
Make sure
Have a
you
good day.
sign out.